Your Lordship, I beg to mention on behalf of my colleague Livika, she had a medical emergency and has to be hospitalized. So if her matters can be urgent for a week.
Which matters?
Hearing item number 30, 34, 35, 36, 34, 35, 36. Item number 34, 35, 36, 38, 39, 40, and 47. 47. 39, 40, and 47.
It has been informed to this court by Ms. So-and-so, learned counsel, government counsel, that Ms. Livika, the government advocate who is to appear in this petition, in these proceedings, had to attend to some medical urgency, and as such is not in a position to appear before this court today. Taking into account the above, the matters, the instant petition stands adjourned to
1 week, Your Lordship. 1 week.
for 1 week.
Much obliged, Your Lordship.
With this, Your Lordship. Lordship, I close the mention item 30.
30? What is this?
Let this matter be come up after 3 weeks for the said counter.
What is the matter about?
It is about the payment of the pending bills.
So what is there? You either admit or deny. If you deny, matter is to be referred. If you admit, pay. That ends.
We are filing the counter certificate. State is filing the counter certificate in that.
Mr. Moaim Chand, the learned counsel appearing on behalf of the state of Nagaland, request for 2 weeks' time for filing the counter in the instant writ petition, in the instant writ proceedings. Taking into account the above, list the matter again on 2nd of July 2024. The affidavit in opposition to be filed by the state has to be filed on or before 28/6/2024.
Published.
Lordship, item number 45. This matter can come up on Monday, Lordship. I have some difficulties today, Lordship.
Why?
Lordship, I have some difficulties, personal difficulties. I've taken the concern of the petitioner on Monday, Lordship, as a fixed item, Lordship.
You are appearing for whom?
I'm for AG, Accountant General. Lordship, this pertains to pension matters, Lordship.
This is matter pertaining to which one?
Pensions,
Pension.
Lordship. On Monday, Lordship.
Mr.
If Lordship.
45.
45, Lordship.
Your name is shown in 46.
No, 46, my
46,
apology.
okay.
46. My apology.
Mr. N. Mujoy, the learned counsel appearing on behalf of the Accountant General, seeks for an accommodation today. Accordingly, list the matter again on 10th of June 2024.
Obliged, Lordship.
Yes, let us take up the matter.
May I please, Lordship? Lordship, I beg to mention item number 42, 43, and 44 on behalf of counsel for the petitioner. Lordship, I was informed that he is out of station for the treatment of his son. So, out of station for the treatment of his son.
Who?
Counsel for the petitioner, Lordship. So, can you list this matter on Monday?
42 to 44.
Yes, Lordship. 42,
Yes,
43, and
Mr. Jamil.
44.
What is that? Matter pertains to what?
The petitioner, I am appearing for Lokayuta.
Ah.
They are challenging the recommendation made by the Lokayuta and the subsequent consequent show cause notice issued by the district administration.
So, what is wrong? The Lokayukta's business is only
Recommendation, yes.
and thereupon the state has taken any action.
Only show cause notice.
So what is there? There is a stay also.
Petitioner is challenging.
Huh? What? We'll see when the matter is taken up. Not now. Yes, Mr. AG, we see you out there in the video. Which matter?
Yes, actually, we have having a few of the regularization matters and the interpretation of some of the circulars of 2004 and circular of
Yes,
2000.
I remember I'm fixing a matter today. Which is the matter?
I just came across those
Miss-
cases.
Miss Chang was appearing on the last occasion.
Please, ma'am.
Muajami.
It's
Where is
item
it?
9, Your Lordship.
You was appearing in that matter.
There are a few,
Yes, yes, it's good that Ms. Advocate
So-
General. Yeah.
so
We
these
find-
matters,
Mr. Advocate General, what I have found out here is
please, ma'am.
you are having a regularization scheme of 22/9/2004.
Please, ma'am.
Thereupon, in 2015, you have come up with another scheme. And
Yes,
that
ma'am.
too, it includes work charge, casual, everybody. And
Please,
you have said that you would definitely, only those people who are in the scale of pay have
please,
30 years. If it is completed as on 1/1/2015, you are going to regularize. That is your scheme.
please, please,
Now,
madam.
if they have not completed, then you will again regularize at the time when they complete the 30 years.
Please, ma'am.
Now, in this case, the petitioner do not complete that 30 years. Now,
Please.
what the petitioner wants is that as he is not going to complete it in terms with that notification of 2015,
Please,
let
ma'am.
him be given the benefit under 22/9/2004.
Please,
Don't
ma'am.
you think that this will have as far-reaching consequences on the state or the policy which have been made in terms with the 2015?
Please, madam.
Because
So,
there is another single judge order which have been placed by the council appearing on behalf of the petitioner. He
Yes,
said
sir.
that on the day when the matter was passed by the coordinate bench out there, wherein it was said that, okay, he does not come within the ambit of the 15, but the state
Right.
have admitted that he comes under 2004, and as such, there is a direction for consideration.
please,
Don't
madam.
you think that is against the judgment of the division bench also?
Yeah. I think, prima facie, it appears to be so.
Hmm.
So what if your lordship would permit me is,
Yes.
because this can have a cascading effect on the state. Therefore, we will have a review of these circulars. And I will get, though I'm told some clarification has been got by them, but I will get a proper clarification, taking into consideration the pros and cons of the matter and also the legality of 2004 circular in the light of the later circular of 2015, which specifies 30 years.
Hmm.
So once I'm well informed of that, then it will be more proper for me to, because of shortage of time, because I just noticed the matter.
Yes.
So if your lordship would give me some time, I will get clear instructions and then report back to your
Because in
lordship.
the division bench, we
Please.
say there's another division bench judgment passed on
Please.
in the writ appeal number 6/2022.
Please, ma'am.
This writ appeal came into existence in view of clause 1 Roman 3 of the 2015 circular.
Correct.
What happened? The learned single judge has passed an order that after 2020, the 2015 office memorandum has ceased to exist, and as
Yes,
such,
sir.
22/9/2004 would come into existence. We said no. It is continues only after 2020. The reservation which was there for regularization at 67% has been reduced to 50%.
Correct, ma'am.
We further held that we make it clear that the office memorandum dated 22/9/2011 would also continue to be available insofar as the same is not inconsistent with the office memorandum dated 17/3/2005.
Yes,
So
ma'am.
this is a division bench judgment.
That's
Now,
right.
once that is so, if a person would not get the benefit in terms of the 2015, can he therefore get a benefit under 2004? It will
No,
have, means 2015 becomes useless.
I think I will have to look into it, and prima facie it appears that those views require correction. So if your lordship would keep it any date convenient to your lordship, when your lordship is, since the matter is, your lordship is seized of the matter, it
Yes.
can be treated as part heard, because your lordship is well aware of this matter. So
No,
I've been-
Mr. AG, I'm a very temporary judge out here.
I'm only saying that.
I
this-
only come for 2 weeks.
No, I'm saying that we don't mind where the hearing is also. That is really not an issue. The only thing is that since you're thoroughly seized of the matter, it may make things a little more simpler. So I would request that this may be treated as part her, subject to your lordship's kind convenience. Because only a small matter has to be clarified. And that would be definitely in the interest of justice. I would leave it to your lordship. Any date which your lordship gives.
In fact, earlier, when the appeal was taken up,
Right, please, madam.
there were certain clarifications given
Please, madam.
by the state. And it is
Please,
in
ma'am.
pursuance to those clarifications, this
My lord.
judgment was passed in the writ appeal. And I don't think this matter went to the Supreme Court.
No, Lordship.
So this has ended to that effect. So something has to be done in that regard. Okay. So what do we put it on some other date
Please,
and
madam.
to take a call on what is to be done in view of more particularly the decision of the single judge now. Because
Please, madam.
this single judge judgment is also passed taking into account the stand of the state. Now,
Please,
the
madam.
stand of the state has been made very clear that he is not entitled to, he may not be entitled in terms of the 15, but he may be still entitled under 2004. And as such, there is a direct, that is in WPC number 312/2021.
Your lordship may keep it any date convenient to your lordships. I would be,
I am here only till 14th. 14th of June.
keep it on 13th of, keep it on 14th
14th will be-
or 11th
Can we
and
keep it
12th.
on can we keep it on 13th?
13th also we can keep.
13th.
No, 13th.
The instant writ petition has been filed by the petitioner seeking regularization. It is an admitted case that the petitioner would not come within the ambit of the notification, the office memorandum dated 17/3/2015. However, the petitioner contends that the petitioner would come within the ambit of the office memorandum dated 22/9/2004.
Lordship.
In that regard, the learned counsel appearing on behalf of the petitioner has drawn the attention of this court to a judgment of the coordinate bench in the case in WP's of the coordinate bench dated 27/5/2024, passed in WPC number 312/2021, where taking into account the specific stand which have been taken, taking into account the specific stand of the state, the coordinate bench of this court had directed the petitioner therein, who also did not come within the ambit of the office memorandum dated 17/3/2015, to be considered in terms with the office memorandum dated 22/9/2004 for regularization. Full stop. On the other hand, when the matter was listed before this court on 4/6/2024, this court had drawn the attention of the to the State Council, the judgment of the division bench of this court dated 17/2/2023, passed in writ appeal number 6/2022. Full stop. From the above, it shows that the judgment of the learned of the coordinate bench dated 27/5/2024 prima facie shows to be in conflict with the judgment of the division bench stated herein above. Today, Mr. K.G. Balagopal, the learned Advocate General, had also appeared through video conferencing and had also submitted that he would like to review the matter, taking into account both the office memorandums, and would make necessary submissions before this court on 13/6/2024. Accordingly, this court fixes this matter on 13/6/2024 for further hearing.
My lord may kindly direct that we may get the copy of the order today, subject to your lordships.
Copy of the order.
please.
Yeah.
I'm
A
deeply
copy
obliged.
of the order be furnished to Ms. Ashton, the learned government advocate for, you can very well take it out. Now there is no problem.
Sometimes we have little problem.
Yes, no, you get it now. There's no problem.
I'm deeply obliged.
For motion, item numbers 1, 2, 3.
Good morning, Your Honor.
Yes, madam.
Petition number 1 and 2, appearing in person.
You are appearing for?
Item number 1, 2, and 3.
Okay,
We
for
are the
whom?
petitioners
For whom are you appearing?
for ourselves.
For ourselves, Your Honor.
Yeah.
For ourselves.
Hmm?
For ourselves, for our baby.
Tijanguli.
Yes,
Who is he?
It's me, Your Honor.
And who are you?
I'm petitioner number 2, Barbara Nunes.
Hmm?
Petitioner number 2, Barbara Nunes.
Okay. Okay. Yes, tell me.
Your Honor, we filed IA 85.
Is this the case regarding the baby?
Yes, Your Honor.
I took it up initially once when
Yes,
it
Your
was
Honor.
there. We asked him to take him to Delhi or whatever it may be. How is the baby now?
The baby is still in the hospital, still in the ICU.
Okay. Well, is this the same matter?
Yes, the same matter, Your Honor.
Okay. Tell me.
So we filed IA 58 and 65.
Yes. What is this IA for?
IA 58 is requesting for the prayers that were removed by the previous council to be put back, reinstated.
Why do you want to make an advocate a party?
Because, Your Honor, the advocate has committed fraud on the court, has committed forgery of my husband's signature and also forgery of another advocate's signature on the Vakalatnama, which was in the court's possession. She also wiped out her name from the Vakalatnama. So it's a very serious matter.
But you have to refer it to the Bar Council. Why don't you
We
take it up?
filed a complaint with the Bar Council already, Your Honor. But we feel since under Section 340 of the IPC, since the fraud was committed on this very court, we feel that this court obviously has the jurisdiction to take steps against those serious actions.
But there is already a direction.
Pardon, Your Honor.
You mentioned it in the petition.
Your Honor, on 14
Oh,
of
yeah.
last
So
month.
and so applicant in person, so and so. The applicant shall take steps, so and so. The applicant shall take steps for service of notice. He didn't say anything on 14/5.
There was two orders passed, Your Honor. Your Honor, the order of 14/5/2024 in connection with IA 65. The court passed the following, that the applicant should take steps to
Okay.
serve notice.
So, okay, this IA 85 is filed in pursuant to the order passed on 14/5/2024.
Yes, Your Honor.
Yeah.
IA 55 is just for the impleadment as per the order.
This is an application filed by the applicants who are also the writ petitioners in WPC number. Where's the WPC? Is the WPC?
WPC 6/2022, Your
There's
Honor.
a WPC. Let's put it in. WPC number 6/2000. What? 6/2022. This is an application for impleadment filed by the applicants to implead the earlier counsel who represented the petitioners in the instant proceeding, in the accompanying writ proceedings. It is seen that this court had in IAC number 65/2024, by an order dated 14/5/2024, had already granted the liberty to the petitioner applicants to take steps for impleading the person or lawyer as one of the party respondents. Taking into account the order dated 14/5/2024 in IAC number 65/2024, this court therefore impledes Ms. Nito Khoza, advocate, as the respondent number 7 to the accompanying writ petition. Full stop. The applicants are directed to file a fresh memo of parties before the registry of this court by 10/6/2024. And on the basis thereof, the registry shall make necessary correction in the cause title of the accompanying writ petition and also update the same in the CIS. IA stands disposed.
Thank you, Your Honor.
And where's the other one? What, there's another IA?
Yes, Your Honor.
What is this?
IA 58 is for the request to put the prayers back, is in connection with IA 65.
What do you want here? Oh, you're all the mother of the man, the petitioner's wife. This is already allowed. This
IA
IA,
58, Your
this
Honor.
you implead your name.
Oh,
That's the
that's,
mother of the baby, so and so, and the petitioner has petitioner allow the petitioner here to present and pursue the case at their own risk.
Yes,
So you are already.
that's IA 141, Your Honor.
Yeah, 141.
Yes. So today it's IA 58 and 65 only.
No, I think close this now as your name, you already appear. We give you
Yes.
the liberty out there and to pursue the case as per your own risk and cost.
Yes, yes, Your Honor.
Yeah. এখন দেখো order pass করছে নি আই Okay, this is an application filed by the applicant, who is the petitioner number 1 in the accompanying writ petition. Who is the petitioner in the accompanying writ petition to implead Mrs. Barbara Nunes, his wife, as the petitioner number 2 to the accompanying writ proceedings, and also to allow the applicant as well as to be impleaded.
I'm
Petitioner
sorry, Your
number
Honor,
2.
if I may intercede. That petition, I think maybe it was given to you by mistake. That petition has already been heard and passed.
Understood,
Today's
but then
matter
also
is
this
IA
needs-
58 and
Understood,
65 only.
madam. This needs to be closed.
Okay, okay. I'm
If
sorry,
we
Your Honor.
don't close it, it will always be shown as pending.
Okay, I'm sorry.
Okay.
My apologies.
And also permit the petitioner as well as the newly to be impleaded petitioner number 2 to present and pursue their case in this court at their own risk and responsibility. This court takes note of that by an order dated 23/11/2023, the said application has already been allowed, and on the basis thereof, there has been a direction also be issued for carrying out necessary correction in the cause title of the connected writ petition. It is also seen that pursuant thereto, necessary corrections have been done. In that view of the matter, the instant application therefore stands closed. Yes, madam, what is this 65?
65, Your Honor, it was for requesting that the court investigates the allegations that we've put forth about the previous council and to take criminal action against the fraud that was committed on the court, the tampering of court records and forgery of my husband's signature, and also forgery of an advocate that is in Delhi, which the advocate has also stated that she's willing to put on affidavit that yes, her signature has been forged.
IC number 65/2024. This is an application filed by the petitioners as applicants for the purpose of seeking directions for conducting an investigation into the allegations stated in the application, semicolon, for taking criminal action against the advocate for the act of forgery and tampering of the court records, as well as to pass such further orders as deemed fit. It is seen that by an order dated 14/5/2024, this court permitted the applicants to file an application for impleading the person of the lawyer as one of the respondents to the instant application. Today, in pursuance to the said leave granted, an application was filed being IAC number 141/2023. This court allowed the said application by directing by uh, 141, no, 85. 185 file also by already have allowed the said application, thereby impleading the former advocate of the petitioner, Ms. Nito Khoza, as the respondent number 7. And actually, it should have been not in the writ petition, it should be in the IA.
Yes,
The
Your
prayer
Honor.
was made in the writ petition.
That was a mistake on my side, Your Honor.
Yes. So he gonna agor order to the asset is impleaded as the opposite party number 7 in the in I number 65/2024. The earlier order, not in the writ petition. So and so. In that view of the matter, this court issues notice upon the newly impleaded opposite party number 7 to the instant application, thereby making it returnable by 2/7/2024. The petitioner is directed to take steps by way of, the applicants are directed to take steps by way of registered post with AD within on or before 10/6/2024. Yes,
Lordship, yes, I will accept the notice today.
you want to
Lordship,
accept it
yes,
now?
I have two questions to be posed on the petitioner's lordship. One question is, why is it that every lawyer that helps them, this court has also appointed a legal aid counsel for him, for them.
No,
Why is it every
understood.
counsel that is,
Madam,
does not last?
I am not,
Another,
therefore, I am
lordship,
not-
I have another
No,
question.
Madam, kindly listen. I am not saying anything to the effect. You see, I would have otherwise asked anything. But there is
Lordship.
already an order passed by my brother Kaketo Sema, wherein he categorically gives them the liberty to file an application to implead you.
Lordship,
So under such circumstances, that application has to be allowed. If that application has to be allowed, the allegations you have a right to rebut. So
Lordship.
notice has to be issued. So notice you rebut.
lordship, I accept the notice.
You
So
want to
allow me
accept
to, the
the
second
notice by-
question that I have,
Uh.
want to pose on the petitioner is, by stripping me of my license and by putting me behind the bar, how is this going to help the case?
Madam, let us not go into that
This
question
case
now.
was, represented pro bono. I was not getting my remuneration. I spent from my pocket every penny for the court fee, for the notarization, for sending the notices, making photocopy manually. I did it in good faith. Now the question is, mens rea, of course, I will be filing my reply. I'll be countering it. Mens rea has to be considered. That is the pertinent question. Mens rea has to be considered by this court. Is there a prima facie case? Can they prove their case? That is one question. Now, I'm also very confused. Particularly, there's an order, IE, that was IE 17, where this court has passed an order. I obtained the order for them. They are not raising issue with that order. Now, a lot of false allegation has been made against me, Lordship.
Madam, I
Yes, I'll be
understand.
filing my
No,
counter
Madam, kindly appreciate one thing.
affidavit.
Once that application has been filed, you have a right to reply.
Yes, Lordship. I will do
I
that,
think
Lordship.
better
I'm
you,
obliged.
You file a reply to that, better. As of now, to say anything out here, I can't record anything.
Yes,
And there's
Lordship.
nothing out there, Madam, kindly appreciate. This court would not take anything unless it is shown on the basis thereof that there is some illegalities being committed. It is another thing, if they are very serious with this application, I can very well ask them. Their basic case out here, if I remember at that point of time, the baby out there was not getting a treatment. And as such, the Christian hospital which was there, they say that we have already given whatever help it is, and now the particular it is what further treatment is required is outside our hands.
Yes,
Initially, when
Lordship.
the matter was moved by Miss D. Ghosh, if I remember correctly.
The order is there, Lordship.
Eh?
Order is there. Order dated 18 February 2022.
Yes. Now, thereafter, what had happened? While I was taking up the matter, I was considering the bench change, and it was taken by my brother Arun Dev Chaudhary. So he passed an order to get this.
Lordship, yes.
But the fact remains, whatever may be, the issue involved out here is as to whether the baby is getting treatment. Isn't it? We are not concerned with other things. You see, one thing, kindly appreciate one thing, both of you.
Yes.
This court have taken or exercised the powers under 226 only for the purpose that it is the right of life of the baby
Yes, Your Honor.
whose needs to be protected, and the best available services or whatever is there should be given to them. That's all. That is the reason why this court has done it. We have not done anything out of any feelings or anything to do about your rights, both of your rights, nothing to do with both of your rights. It is only for the consideration of the baby we have taken care of. So would it be necessary at all to transgress to anything else rather than only consider the interest of the baby? Both of you. Put a
We
question
believe
to both.
so, Your Honor, because her actions, the advocate's actions has caused our case to go into res judicata. Falsely to fall under that. Her actions have caused our case to fall under res judicata by fraud of the court, by forgery of signatures, submitting IAs without our knowledge or consent.
What is the res judicata which has happened?
Pardon?
What is, how her actions have affected you?
Because she's removed all of the prayers in the
Prayer for
writ petition.
compensation.
You see, the first order you see, which I passed. First order, I said that we are not going to consider the other things except the baby. First order you see in this writ petition.
Yes, Your Honor.
Forget about what she says or what she does, that we are not concerned. See the first order which I passed on 18 to 2018.
Your Honor, I
Kindly
believe that
see-
the court should be concerned what she says and does,
Kindly
because
see
she
one
committed
thing.
fraud on the court.
I did not even appear that day, Lordship.
On, no,
Yes,
no,
you
you
did. We've
didn't. You are
had a
not there.
phone call
No, she
conversation.
didn't
You said
appear
so.
then. It was appeared by Ms. D. Ghosh, I remember. You kindly see this. The court also is of the opinion that the respondents are not necessary or proper parties to the instant writ petition inasmuch as the issues involved herein, and accordingly their names are struck off. The registry is accordingly directed to rearrange the numbers of the respondents. The instant writ petition has been filed by the petitioner, who is the father of the baby, in the ages about so and so. The grievance is that on account of certain unpaid dues, the respondent number one, which is an institute of so and so set up in the year so and so, so and so. Though there are various allegations made in the writ petition pertaining to the negligence of the respondent number one and the doctors therein, the learned counsel for the petitioner submits that she is not pressing for the relief sought for in the instant and would file appropriate application for deletion of the same.
Yes, Your
Then-
Honor, she is requesting the
she.
court.
It's not, it was not her.
Hmm.
At that point of time, Ms. D. Ghosh was appearing.
Well, I spoke with her on the phone that day. She said that she appeared in the court with her as
No,
well.
no, she never appeared on that day.
We have the phone conversation. We can
Huh?
submit it with transcription.
You
They
have-
record all phone calls, even my phone call they record without my
Yes.
consent, Lordship. That is why I decided not to appear in the case in the first instance.
No,
Lordship.
whatever may be, on that date, Ms. D. Ghosh has appeared.
Lordship, yes, the
And
order
you
is very
see,
clear.
the reason why I said it was at my instance that you cannot press the other reliefs, else if other reliefs are played, that you say that you want some allegations against the doctors. We made it clear that we are not concerned with anything. Only thing we are concerned is as regards the baby.
Your Honor,
And if you have anything problem out there, you should file an appeal against this order.
Yes, Your Lordship.
Then we passed this order for the sake of the baby, saying that the baby out here needs to be protected, and therefore, you see, this judgment, Union of India Mulsan Khatri Ram Trust was only brought in out here to show that when the Christian hospital is receiving some grants of some of the land at that point of time, therefore they would be bound to give them the treatment. That was the ground. She had nothing to do at that point.
and what
of time,
about the
neither
gross
she
medical
appeared.
negligence that was committed against the baby, Your Honor? Your
You
Honor,
see,
the
kindly
baby.
don't spoil. You don't spoil. You see, then the matter came up again on 8/3. Okay. You are aggrieved because of the fact that she had removed certain reliefs.
including
In the
forging
petition.
signature, tampering the vakalatnama that is in the court's possession.
Forget about that.
All those issues.
First, you are as regards the reliefs. Okay. Let me reject those reliefs now.
IU
Do
58,
that.
Lordship.
You can't do that in that regard. We have taken, this court have taken a sympathetic view on the matter and you have taken this court for granted.
No, Your Honor, I don't agree, Your Honor.
Absolutely. This is not at all called for. We don't expect such things from you.
Your Honor, the opposite
And it
parties.
is at the instance of this court. She did, on that date, nobody appeared. You see, there are various allegations which are being made by the Christian hospital against you, against the petitioner number 1, that he has been doing all these things and everything to that effect. This court came to your aid by giving all the whatever benefits which can be given. There was a direction asking the pediatrician and everything to look into this, what is to be required. We also asked as to whether in the northeastern region there is any facilities for giving this thing. When it came out that nothing is there, we further directed out there on the first date itself that the Christian hospital shall continue to provide all things, and the amount, whether how much they would be entitled, we will impose the state about this. This was the order.
Lordship, yes.
And you are transforming this petition, which is for the aid of a baby, to anything else.
It is
The
still,
only consideration we want out here is how, otherwise, as regards the other reliefs, you have to go to the civil court. Go to the civil court. What are the other reliefs? See?
Your Honor, the fraud was committed on this very court under section 340 of the IPC. This court has the jurisdiction to take action.
Admit, issue direction to the respond number 1 and to provide complete medical setup of records with so and so. Issue direction to conduct an independent inquiry into the negligence committed by so. Why are you not going before the consumer forum?
The consumer forum is not.
There is a forum for that. How can a writ be issued? And if the consumer forum is not sitting out here, then very well. If it is not, then we file a suit. But a consumer forum would definitely take care of this. The doctors come within the ambit of the consumer forum. That is the reason why issue direction to provide adequate compensation that would be required by the petitioner and his family to take care of the baby after she was discharged. Now, whether the question as to whether there was a negligence on the part, how can this court look into it under 226? These are the reasons why we asked to kindly remove these. We are only concerned to that effect that only one thing we were concerned that how the treatment can be given to the petitioner, your daughter. That's all.
Your Honor, this court has seen previous cases of the same medical negligence matters and has heard the cases and has come to a conclusion on those cases. So I don't see why our case can also not be heard.
Which case?
WPC 236, 2018.
Show me that. Where this court has done.
This case was also a matter of medical negligence, and it was filed by the same advocate, Ms. Neto Kozo, in 2018. And there is many more as well, Your Honor, not only this one.
If I'm correct, Lordship,
May I reply?
that case was about, it was a public hospital, Lordship. And it was the state's responsibility to appoint doctors. And the doctors was not appointed. Consequently, a mother has died at the time of delivery.
Not
It's
that
a-
case.
Let's come.
Which one? If I'm correct, because I don't have a copy of the order.
A patient that was denied
You have a
treatment.
copy? Sorry?
A patient that was denied treatment.
That is a private, is it a HIV related?
Yes.
Okay. That is also a government hospital.
Christian Institute of Science, Health and Research is tri-party with the government. All the board members are the state leaders.
I don't have a copy of the order with me, but if I'm correct, Lordship, an HIV positive patient was
Anyways,
denied
you do one
treatment.
thing, you file your reply.
Lordship, yes.
You file your reply, we issue it notice. Okay? Because I would have otherwise not done it because otherwise earlier the court had issued notice for 3 to 6.
Lordship,
In
these
this
are
I.
different cases, Lordship.
No, in this I. 65, the court had already issued notice. So I can't now say that I'm not going to issue notice. The
Lordship.
matter is already in session. Okay, can issue notice. Yeah, so you accept the notice?
Yes,
Now, yeah?
Lordship, today.
So and so. Yeah, has impleaded, he has already impleaded. So taking into account that the the opposite party number 7, who is a counsel, has appeared in person and submitted that she would accept the notice. Accordingly, a copy of the said application be served upon her during the course of the day. This is the matter again on 2nd of July 2024. In the meantime, the opposite party number 7 as well as the other opposite parties shall file their affidavit.
Obliged.
Thank you, Your Honor.
For motion, item numbers 4 to 6.
Please, Your Lordship. Lordship, this is an application praying for the leave of this court to allow the applicant to represent her deceased husband, Lordship, as a legal representative in WPC 192 of 2016. Her deceased husband was the writ petitioner.
What is this?
Lordship, here,
Who is the
the,
applicant?
the wife, Lordship, the wife of the deceased.
Why? Okay, who died?
Lordship, the writ petitioner, Lordship.
Husband.
Yes, the husband.
Husband died.
Yes, Lordship.
Now, if the husband dies, what was the husband's case?
Lordship, it was regarding promotion, Lordship.
Then what remains? Can he get a
Lordship,
promotion?
Lordship, if the
Can a dead
petitioner,
person get a promotion?
Lordship, if the petitioner succeeds, he will be entitled to
Yeah, this matter has abated now. It's a
retirement
case of
benefits of the
promotion,
higher
you
grade.
can't help it, madam. Yeah, and this is, kindly don't say representative, it's a substitution.
Yes, Lordship.
It's a case of substitution of the legal representative
Yes,
of so and so,
Lordship.
but here you don't have a right to sue. The right to sue has ended with your death.
Lordship, she's just praying to you.
What is your case? Both the petitions.
Lordship, in the second writ petition,
What are you
I'm
asking?
for
Let us
respondent
see.
number 4.
Let
Lordship.
us see the relief. Quash and set aside the iman and direct the heir to restore the notification dated so and so. So and so insofar as it designates the post of system as an ex-cadet post, direct the state to rectify the list and show the name of the petitioner as serial number 2 in the list of ex-cadet. Now, what benefit will you get with this?
Lordship,
If
his
the petition is allowed?
retirement benefits, Lordship, he will
The
be.
retirement benefits.
Yes, Lordship. Lordship, during the pendency of the case, Lordship, the petitioner retired in the year 2021, Lordship.
Then,
So, Lordship.
so
but
your
Lordship,
pensionary benefits would become more.
Lordship, to a
And,
higher grade, Lordship.
and consequently, there will be higher family pension.
Yes, Lordship.
Okay.
That's what we are praying for, Lordship.
In both the cases,
Lordship,
what is the second one?
The second one has been filed by the association, Lordship, challenging my seniority.
We are not
Lordship.
concerned with that.
No, Lordship. But it's clubbed together, that's why it's listed to the Lordship.
Second one, we are not concerned. This is it. I hope. And why do we have two missed cases or one missed case? IA number 88 of the 2024. This is an application filed by the applicant who is the legal representative of the writ petitioner who unfortunately expired
On 7th March
on
2025.
7/3/2024. The counsel appearing on behalf of the petitioner applicant submits that the applicant herein should be permitted to pursue the accompanying writ proceedings on the ground that if the reliefs which have been sought for is allowed, the applicant who is entitled to the family pension would be getting a higher family pension. Also, taking into account the above, taking into account that the right to sue even continues after the death of the writ petitioner, this court substitutes the applicant against the writ petitioner, thereby full stop. Accordingly, full stop, against the writ petitioner. Accordingly, the instant petition therefore stands allowed. Full stop. The applicant, the counsel for the applicant is directed to file a fresh memo of parties before the registry of this court on or before 10/6/2024. And on the basis thereof, the registry shall make necessary correction to the accompanying writ petition and also update the same in the CIS. I stands allowed.
Much obliged.
For motion, item number 7.
Motion? Yes.
Yes, my lord.
Yes.
This
then-
is the writ petition
Ah,
for seeking for direction to go for the survey and ascertain the damage caused by the,
for what?
for the construction of this National Highway 29. From Chumu to this Chupja, there are 12 villages. And then there are certain individuals, they agree. The course of action was said that after acquired land, the road construction was done. While constructing, there was further damage.
Whose land?
That is the aggrieved party, 68%
No, who-
they affected. My lord, it should not come up to this stage. Why the petitioner come up to this stage is that while they are approaching to the concerned authority and serving the notice for the consideration that representation, that they are ignored and they have been not taking it. Therefore, this petition is compelled to come before this honorable court for direction to go for the survey to
No,
ascertain.
Mr. Counsel,
Yes.
first of all, your land has been taken.
Your Honor, we are the landowners which is passing through National Highway 29. So the government and the National Highway, they have acquired the land. After acquiring, they have constructed. While constructing, they damage beyond the acquired land. For that, we have represented to the concerned authority, and they never take to consideration. So it caused damage and suffer. It is only to ascertain whether.
Show
there
me the
is-
photograph where you have, it has been
Your Honor,
damaged.
those photograph is the affected area. Your Honor, for your information, now Your Honor has to direct to the.
Kindly come to page 42, those photographs. How is it damaged? Oh, this is this Dimapur highway.
Yes, Your Honor.
Then
From Chumu to,
it is almost, half of it is already taken away by the landowners.
Your Honor, that is the issue why the concerned authority are not coming for the joint survey and verify what area, up to what extent they damage, that has to ascertain. That was the representations seek for that. So since they are not complied with, there is no other way, I mean.
Whom are you representing?
I'm representing
No,
for
no,
the,
no.
for
Whom you
68.
have submitted the representation to?
That representation page number 39. So these are the grievances that addressed to them.
To given to the chief secretary.
Yes, Your Honor.
Then what happened? Why you are not representing to the local body nearby, to the deputy commissioner? Why you are not doing that? Directly you go to the chief secretary.
Your Honor, it was, yeah, there are so many activities has taken place before filing this petition. Approach to the Dimapur commissioner, and then the Dimapur deputy commissioner says that this issue has already shifted to Sumukirima. And then we approached to the Sumukirima.
The council, if it was in Gauhati, I would have dismissed the petition. But it is in the Kohima, I'll issue a notice.
Your Honor, this is the last resort for me to seek the
I'll issue a
help.
notice. Nothing is going to happen like this. You should have represented the deputy commissioner. Look here, kindly look into this.
Your Honor,
That this is the land which you are damaging, kindly do. Because you see, I'm telling you why. The deputy commissioner can thereafter, you make a copy to the chief secretary, it's a different thing, all this thing. But who is actually on the ground? You have not done that.
yes.
Now,
my
what
lord.
you have done directly, approach the higher authorities out there to the chief secretary. Chief secretary has hundreds of works. What is he going to do?
Yes.
You should have represented them. Look here, this is the damage caused, and as such, we are kindly assess the damages.
Yeah, yes, my
You have not
lord,
done that.
that we have already given the
Verbally.
notice, yes, to the government, to the deputy commissioner, board, to Dimapur and Chumu and Kohima. So sometime they have surveyed, but they bypass, they ignores our.
And you only
represent-
approached once in 20th of March 2023, and thereafter you have forgotten. You have good to take the beautiful photographs which have been enclosed there with. But otherwise, there's nothing.
Your Honor, prior to that,
You have to be more specific out here. The where, how is the damage caused and all.
Your Honor, that is the issue that they have to come and see the area, how damage goes, the additional, which is damage more than the acquired land.
Anyways, as I told you, it is in Kohima, I'll issue a notice. Otherwise, this is a fit case for dismissal. Issue notice making it returnable by 11th of July 2024.
11th July.
Steps be taken upon the respondents. Mr. Aim Song appears on the learned edition and Advocate General appears on behalf of the respondent number 1, 4, 4, 5, 5,
8 and 9
5, 5, 5, 8,
and 9.
and 9. So, as such, extra copies of the writ petition be furnished to him. In respect to the other respondents, the petitioner is directed to take steps by way of registered as well as usual within 3 days.
My lord.
For motion, item number 8.
Yes, madam, what are you asking?
Yes, may it please your lordship, this writ petition is filed by the petitioner to be reinstated in the service. The petitioner is an employed SSCT, ARMR, Sepoy.
You have been discharged, removed from service?
Yes, yes, your
In the
lordship.
year 2019?
Yes, your lordship.
Why have you woken up after 5 years? Or the petitioner didn't find you?
No.
There's some good reason for that.
Yes, sir.
Why
Yes,
you
your
have woken
lordship.
up after 5 years?
Yes, your lordship. In the year 2019, he was removed from the service, and in the year 23,
Where is your
03,
explanation in your petition? Why
Yes.
you are delayed after 5 years?
Yes, yes, your lordship. He went back to appeal in the IGP of Bangalore, Karnataka in the year 2020. And after that, since his two charges were, the first charges was for plural marriage and the second charges was for leave application for forged seal of the commandant.
You filed a suit. Divorce.
Yes,
Divorce and all has also happened. That is the reason. Oh, madam, there is nothing out there to show.
Your lordship,
After
in this case,
2019, there is nothing. Was in service and he was terminated at Nagaland. The initial appointment of the himself is at Nagaland. He dismissed at Karnataka. I can file the proceeding at a place where the board of action is. Oh, you moved Bombay,
yes, your lordship.
and therefore this order has been passed.
Yes, your lordship, since the petitioner have no knowledge about the
Okay, we issue
jurisdiction.
notice.
Okay, your lordship.
Issue notice making it returnable by 11/7/2024. Madam, you are appearing?
Yes, I'm for my senior young Gauhati
No,
CGC.
you,
I'll be
not
accepting
senior.
notice.
So and so appears on behalf of the respondent numbers 1 to 5 and accepts notice. Under such circumstances, the petitioner the counsel for the petitioner is directed to serve extra copies of the repetition upon the counsel, upon the respondent, upon the said counsel appearing on behalf of the respondents. Full stop. On or before the next returnable date, the respondents shall file their affidavit.
Much obliged, your lordship.
For admission, item number 10.
May I please, my lord. Lordship, I'm yet to receive instructions, so can you grant me another 3 weeks, my lord?
You don't want to file, what to do? What is the case?
Land ownership appointment.
Madam, don't be that he will ask for time and you will get it anything. Don't trust this court. Yes, what is your case?
Your lordship, land ownership appointment.
Huh?
Land ownership appointment.
Yes. Now they are challenging the appointment of the private respondent who is appointed on compassionate basis. They are coming on the basis of land ownership. They say that they have donated land for the construction of a school. That is their case.
Written
Yes.
agreement. Written agreement, oral agreement, how?
Your lordship, I'm very new to this case.
See?
And now,
She is only helping you to get an agreement.
And now we have the ascertain from the district administration, which we are yet to receive. The department is yet to receive, lordship. That is our difficulty.
And who is appearing for the private respondent? Somebody has filed an affidavit. Private respondent has filed an affidavit.
Lordship, I'm appealing for private respondent number 6, Lordship.
Yes, what do you have?
Lordship, they are challenging my appointment, whereas I was appointed on the basis of compassionate appointment. And they are seeking appointment on the basis of land ownership, Lordship.
So it is the state who should clarify.
Lordship.
And the state is not filing the affidavit.
The state has not yet filed their affidavit.
So, yes. Pay her appearance cost today, 10,000? 10,000? Let the state pay the her appearance fee. She has come all the way to attend this matter. And you, because of you, the matter has got delayed.
One more chance.
It is seen. The instant writ petition has been filed by the petitioner being aggrieved by the non-consideration of the case of the petitioner for appointment on land on land ownership basis. The petitioner have also challenged the appointment of the respondent number 6 on the ground that the respondent number 6 could not have been appointed on compassionate basis. It is the opinion of this court that for the purpose of deciding as to whether the petitioner whether the respondent authorities were justified in doing so. The affidavit in opposition of the respondent authorities are required to be filed. However, it is seen that in spite of the matter having been pending from the year 2022, no affidavit in opposition has been filed by the respondent authorities. Under such circumstances, this court grants a final opportunity to the state respondents to file their affidavit on or before 28/6/2024. List the matter again on 4th of July 2024. It is made clear that if the respondents do not file, states do not file the affidavit, this court shall decide the instant proceedings on the basis of the materials available on record. Next time, be ready. You're not ready, so no cost.
For admission, item number 11.
Yeah, please, Lordship.
Yes, Mr. Gumi.
This is a similar case, Lordship, with the previous item. Petitioner is seeking appointment on the basis of land ownership, and they have met one appointment allegedly on compassionate ground. The only thing which I would like to submit is compassionate appointment all over the state. They can make appointment. They have pull-up options, and so far as the landowner is concerned, their right is confined only to that particular office where the building is situated. Landowner will not have any other right in the other places. Whereas the compassionate appointment, all over the state, anywhere they can make appointment. And the order of this honorable court is not that the petitioner should be appointed in that particular establishment. It's not that. It is a common order as is normally passed. They can appoint anywhere. In Kohima, there are plenty of posts, so many office establishments. They could have appointed.
So you mean to say the scheme of compassionate appointment of the government of Nagaland is subservient to the scheme of granting appointment on land ownership basis?
Government may have,
because
government may not have taken into consideration of that fact. So there is a clash between two rights. So which rights will have a weightage, more weightage? That will be the criteria. That is why I am submitting on the basis of an agreement. The landowner is getting right, and Lordship is very well aware about the scheme for providing appointment to the landowners. So far as the ownership of is concerned, there is no dispute. Another ground which the government has taken in my case is that in the year 2002, my father was appointed on the basis of land ownership. So as per the scheme, there can be only one appointment. That is the contention. But how my father was appointed, on what basis? He was appointed on contingency fixed pay for a period of 6 months, and that was extended for another term. Thereafter, on completion of 1 year, he was terminated. So that is the contention of the state respondents, which shows that so far as ownership is concerned, there is no dispute. They are admitting that fact. And the petitioner was also appointed in 2017 on fixed pay, and he's still continuing on the fixed pay. And the government said that.
Government stand is very specific, that your father has already been paid the money. Isn't it?
No,
yes.
That is not the issue.
Yeah, if I'm
No,
not wrong.
Even if compensation is paid.
Petition number 6 of 2023. See the affidavit of the respondent number 1, 2, and 3. It categorically says.
Even if compensation is paid, when there is, the policy says, when there is an agreement providing the clause for consideration of appointment of landowners, that is already there in the scheme, and government is admitting that fact, yes. But then only ground they are taking is, it is another private respondent has been appointed on compassionate ground, number one. Number two, your father has been appointed on the land ownership basis. So since one appointment already given, you cannot. But that appointment is only for a period of 6 months. That is on contingency basis. And that was extended for another 6 months on expiry of 6 months. Then my father was terminated from service. And actually, any person who is appointed on the basis of land ownership, then it should be the regular appointment, Lordship. Otherwise, the very policy becomes meaningless.
And your father was not regularized.
No, terminated rather.
But what do you say about the payment of compensation?
Compensation paid.
Then
but-
how do you get it as per the new scheme? Can a person get compensation as well as also a job?
Policy I have enclosed, Lordship, in the page 28.
Yes.
Clause 3A. That's Lordship correct? If other cases prior to 26/7/2005 and subsequent to the setting up of administrative and block headquarters on freely donated land, where a specific written agreement exists, providing for employment to the landowner, the claim of landowner for employment should be settled in terms of such agreement. So in terms of such agreement, now Lordship will find the agreement at page 14.
14.
Yes, type copy. It's a short agreement. Second paragraph will be relevant, others are formality only. Whereas the PHCD of Nagaland government requires about 3 acres of land for construction of office and store building, staff quarters, other houses as may be required for PHC subdivision Mukokchung at a convenient place at Mukokchung. And whereas the second party owner of plot of land measuring about 3 acres at a such convenient place at Mukokchung, which the second party intends to offer a plot of land measuring 3 acres, more specifically described in the schedule below, with the following terms and conditions. And the first party has also agreed with the approval of the subordinate engineer PHE to accept the said plot of land for the said purpose and to abide by the terms and conditions
Now, understood.
thereafter described.
You see the 4 conditions. One of the conditions is that you are going to get 2,500. The 4th condition is preference will be given. Okay. Now kindly come to 3A, which you have referred to.
Lordship, kindly come to next page, page 15.
That is what I'm saying.
The
There are
terms
4
and
conditions. First condition is, the second condition is you'll be paid 2,500 rupees.
Yes.
The 4th condition is you'll be given a preference.
Yes.
Now kindly come to 3A
Yes.
of that, page 28.
Yes.
If in other cases prior to so and subsequent to setting up of the administrative and block order on freely donated land, how do you take care of that? Remaining is okay, on freely donated land.
B is also important, Lordship.
See, yes.
If there is any claim for providing employment as a result of oral agreement, the department concerned shall refer the matter to the Deputy Commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply orders, has been given in the past. Written statements from the witnesses, that is the government officials of the concerned
No,
department.
this has nothing. This has nothing, no relevance. Relevance is 3A, freely donated land. How do you take care of that? Some other day?
Lordship, the government advocate also, Lordship.
Eh?
The concerned government advocate.
Is also
indisposed. She is not keeping well, Lordship.
Who?
The government advocate.
Okay, when a government advocate, when I'm dismissing it, you should be happy. Then, what do you need the government advocate for? Mr. N. Angami said, fill in issues. That's no problem. But should this court keep on dismissing Mr.
Well,
Jamil's
well.
matters? Yesterday also I dismissed one.
Well,
Don't look so a very poor state. But the problem, Mr. Jamil, is freely donated. There has to be without anything. What do you want? Some other date? Keep some hopes alive for the petitioner for a better judge. Otherwise, your case is to be dismissed on the even on that ground, because you don't come under 3A, freely donate.
So many appointments have been given by the government because there are about 14 departments in my land. In all the office establishments, they have given the appointment laws on the basis of land orders.
You better off then. There are other departments, try in the other departments. If I dismiss it, other departments goes.
Let the compassionate appointment be adjusted in the other
Let
department.
him be there. Let him be there. Better you do it for others. Without that, what to do? Because otherwise, this goes against you, this freely donated land. When the amount of 2,500. Your basic case is, look here, you have given me an appointment as a contingency. It has to be, when an appointment is made in compassionate ground or land ownership grounds, definitely it is a case here. And I also agree to Mr. Jami on that aspect, that this land ownership has a superior right than the compassionate right, but not in your case.
My appointment is still continuing. In 2017, they have appointed me, but it is on fixed pay and I'm still continuing even till date. So when a vacancy, regular vacancy arose, my case ought to have been considered instead of the compassionate appointment. It's not that I'm an outsider. I'm still in the department working, but due to not availability of the vacancy, I was allowed to work on fixed pay.
Let us not go into the land ownership basis.
Lordship.
I can very well say one thing, that you having been appointed as a fixed pay, and one of the conditions stating therein is as a preference should be given, you should have been considered for regularization instead of to any post in that area. However, not touching on response number 6. And as such, for a direction for consideration in terms with that agreement, but not on the basis of land ownership. Land ownership
Lordship,
you cannot.
taking into account of the policy of the government, in the same package, compensation per square feet, and the consideration, right for consideration for appointment of land owners. It is the same package. It's not that since you have already got the compensation.
No, your agreement is okay. Problem is this notification would not apply. Freely donated. So what to do?
Some other date may be fixed. Lord.
The request of the learned council, it has been brought to the attention of this court that the state council, what's his name, who is not well?
Ms. Pichano, Mrs. Pichano.
So and so, who is representing here is not well, and as such, some time has been sought for from the state respondent. Accordingly, matters can be adjourned to be listed of 2 weeks.
deeply obliged.
Yes, what is it?
I for petitioner, my lord, I am appearing on behalf of P. Suren.
What is it? What do you want?
Here, the state have not filed their affidavit yet, my lord.
Who?
State respondents.
They've not filed?
Yes.
They filed?
My lord, I'm appearing on behalf of state respondent number 2, 3, 4, 5, 6, and 7. We are yet to receive instructions, Your Worship.
Let us see what is it.
This
What
is
is he
about
asking for?
payment of damaged compensation.
Who are you?
I'm land owner, my lord.
And what are you asking for?
Here, my lord, my land, my private land was converted into a community land, and the compensation was not paid to me. And since I'm aggrieved, I have approached the Honorable Court. There are 2 petitioners, my lord.
So isn't this a dispute between you and that village? Respond number 10? Because the respond number 10 says that they have already received.
It's among the it is respondent number 6 also. 6 also involved, my lord.
Understood, whoever it is. Respond number 6 or respond number, is respond number 10, who has said that they have received it, isn't it?
Your Lordship, it is community land. It was never their land.
Understood. So whether he is entitled to that compensation, you have received that amount.
Yeah, they have received their own amount. Your
No,
Lordship.
understood. The amount has been duly released by the state authorities. And the respond number 10 categorically says that he is not entitled to the amount. The amount only is a community land which will be only paid to that village council.
Yes, Your Lordship.
Now, if it is so, isn't that purely a civil dispute between you and the respond number 10? Why do you involve the other people?
My lord, here in this case, the state have paid the money.
So what?
So
to pay the money to them. So you want to get the money from them. You have to prove that this is your land.
I proved,
and
my
this
lord,
is
in my
how
petition.
in a repetition. How? We don't have even that witness box here.
The land holding certificate issued by the
So
village.
what? Whether that certificate is actually genuine or not, it is for the trial court to decide.
My lord, my prayer is let the state file their affidavit and
Forget about
we
the
can seek
state.
for
We are
hearing.
not concerned with the state. We don't require the state. When the respond number 10 categorically files an affidavit stating that this is a community land and as such the respond number 10 have the right over that compensation, not you. So it is a dispute between you and the respond number 10. The state have duly paid the amount. And this respond number 10 says that the due amount has also been paid to you. How is this court going to adjudicate that said issue? This type of matter should not be pending. To dispose of, giving you the liberty to go and file civil suit against respond number 10.
Here, my lord, I'm appearing on behalf of Peace Friend, who is the leading counsel.
So what?
The mirror may
You
fix-
appear for whoever it is. This is the facts of the case. Can't help it. You can't improve the thing which is there. Your basic case is you are entitled to this amount pertaining to your land, which the state did not pay it to do. The state, whether whatever they say, the payment has been duly acknowledged by the respondent number 10 that they have received and also have given you the share. So under such circumstances, if that be so, your dispute is against respondent number 10. Let's see the respondent number 10's affidavit. It categorically say claims to be the owner of so and so, and the petitioner number claims to be the owner of here. These structures belong to so and so and not to the petitioner as claimed. The entries in this regard in the charge shown in the assessment on India is clear. Entries to which the petitioner has been paid, damage from say is also clear. In the chart showing the assessment of damage of so and so, for the roots of so and so, the assessment of damage, he is authorized his son to receive the aforesaid sum as compensation under this head. On receiving the comment, his son signed the receipt and so to vacate the area. So with all these things, these are absolutely disputed facts which needs to be adjudicated before the trial court. Go to the civil courts. We close this petition. It can't happen like this.
My Lord, in the interest of fair hearing, it may fix after a week, my Lord, since
What?
I'm not arguing counsel here.
You are standing out there, you are arguing. Matter ends there.
Since I'm not the leading
When
counsel,
is your
a fair chance may
senior
be given
When is your
to the
senior
petitioners
coming?
to prove their case, my Lord.
Where is your senior?
He's in Dimapur, my Lord. In Dimapur. He's in Dimapur too.
List the matter tomorrow at 2. No, list the matter tomorrow. We'll take it up tomorrow. Ask your senior to be present.
Please, my lordship, my presence may kindly be reflected in today's order.
But give your all your names. You put I have a different, I don't mention anybody's name out there. So put everybody's name together like this. The matter upon being heard, this latter matter be taken up. This court is of the opinion that the matter earlier. This court have duly heard the learned counsels appearing on behalf of the parties. The counsel appearing on behalf of the petitioner submits that his senior would like to further address the matter. Accordingly, this court fixes the matter tomorrow. List accordingly.
Bless my lord.
For admission, item number 13.
Your Lordship, the state government has, state council has sent the affidavit for vetting.
Who?
On behalf of Pichano. If the matter could be listed in 1 week, we'll be filing it.
Yes. On what basis you are entitled to?
On the basis of land ownership lodging, notification.
You come under 3B.
Yes, Lord.
Land ownership.
Lordship.
And the respondent number, who have appointed?
My contention is that
Respondent number
he is-
3 is who?
Yes, 3 is,
Lordship, I'm for respondent number 3, Lordship.
Yes, he has been appointed.
he has been appointed Lordship.
On what basis?
Lordship, without any selection process in violation of the constitutional scheme for public employment Lordship. And he was not a landowner Lordship. So my prayer
He
is
was
that,
appointed without any selection process.
no Lordship. No,
And
sir.
on the other hand, you were entitled as per 3B.
Exactly Lordship.
What does the state say in their affidavit?
State is yet to file affidavit Lordship, as well as the
Why?
primary respondent Lordship.
We'll be filing it in 1 week. We have sent it for vetting, Your Lordship.
It is the case of the petitioner herein that the petitioner is entitled to be considered for appointment as to the post of the chowkidar against the vacancy which arose on account of the demise of one Sri Yai I Konyak on land ownership basis. The counsel appearing on behalf of the petitioner has drawn the attention of this court to the office memorandum.
Page 18 Lordship, 1/8.
Office memorandum
Notification.
dated 5/3/2018
Lordship.
and submits that the petitioner has due rights in terms with clause 3B
Lordship.
of the said office memorandum. It is the further case of the petitioner that the Respondent authorities have most illegally appointed the respondent number 3, that too without even carrying out any selection process.
Lordship.
Full stop. It is however seen that in spite of the fact that the notice was issued by this court on (18/5/2023), no affidavit has been filed by the respondent numbers 1 and 2. Full stop. The learned counsel appearing on behalf of the petitioner expresses urgency in the matter, taking into account his deprivation. Accordingly, list the matter again on 2nd of July 2024. The affidavit, this court for the interest of justice grants time till 28/6/2024 to the state respondents to file their affidavit. It is made clear if the state respondents fail to file their affidavit on or before 28/6/2024, the instant writ petition shall be taken up for disposal on the basis of the materials already available on record.
For admission, item number 14.
Please, Your Lordship. Here in this case, the petitioners are contemplating to withdraw the case, but since it's an association, they have to call up a meeting and then pass a resolution. So kindly allow us 2 weeks time for the association to conduct a meeting and then withdraw the case.
Unemployed Trained Nurses Association.
Yes, Your Lordship.
Represented by its president. Who is the president? Who is the
She's not
president?
here. One of his members. Your
There has
Lordship.
to be some president or something named, don't you think? Mention in the
Billy
petition
Tochobe, it's in the affidavit, page 18. Page 18.
that he is the president who is entitled to do so.
No, but since it's an association, they have to take the consent of its members, so they're contemplating to call up a meeting, Your Lordship. They have to call up a meeting and then take a decision, because otherwise, almost all they have decided to withdraw the case, all the members, but they
Going
have
to
to pass a.
withdraw this case?
Yes, in this case.
Withdraw?
Not today, Your Lordship, they have to pass a resolution, the association.
If that's the case, if they want to withdraw, Lordship, and since they are saying the association, so I have no objection to that.
The counsel appearing on behalf of the petitioner submits that the petitioners would not like to further pursue with the instant matter. However, he submits that as the petitioner is an association, a formal resolution is required. Under such circumstances, he seeks for an accommodation of 2 weeks. List the matter again on 24th of June 2024.
Much obliged, Your Lordship.
For admission, item number 15.
May I please, my lordship?
Yes.
Lordship, I have an instruction to withdraw this case.
Oh, very well. Mr. So-and-so, the learned counsel representing the petitioner submits that he has instructions to withdraw the instant writ petition. First, Mr. N. Angami, appearing on behalf of the respondent state, submits that he has no objection. Accordingly, the instant petition stands dismissed on
Lordship,
withdrawal.
Lordship, may I please?
Eh,
A liberty may be.
For
may be
liberty for
given.
what?
In future eventuality, if there's any.
You ask for what?
Lordship, then in that case,
No,
Lordship, this case.
Then you have to give me the circumstances if you
Lordship.
want the liberty.
Lordship, in that case.
Direct consider the petitioner's case for regularization in terms with the OM dated 4/8/2008
Yes, Lordship.
and
this-
OM dated 11/8/2016. Impugn circular dated 6/4/2018. Tell me
Thereby,
why you want
Lordship.
the liberty now?
Yes, thereby, the state government have formulated a new policy decision. And an office memorandum was issued on 16th of March 2024.
2024.
Lordship, yes.
Show me that. Tell me that.
I have preferred this with petition.
Now, liberty one
Seeking
has
for
to
a
record
consideration
reasons. Na?
in terms of the
Counsel,
office memorandum.
liberty if it is to be given, one has to record reasons.
Thereby, Lordship, the previous office memorandums becomes redundant in view of this new office memorandum. Lordship.
Okay. Now, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. N. Angami, the learned counsel appearing on behalf of the respondents. This is a petition filed seeking a direction upon the state respondents for consideration of the case of the petitioner for regularization in terms with the office memorandum dated 4/8/2008, as well as the office memorandum dated 11/8/2016. In addition to that, the petitioner have also challenged the circular dated 6/4/2018. The learned counsel appearing on behalf of the petitioner submits that the government of Nagaland Personal and Administrative Reforms Department have recently come with a new office memorandum which stipulates the policy for regularization of Group C and Group D contract and ad hoc employees appointed prior to 6/6/2016. He therefore submits that in view of the recent development, nothing further survives in the instant proceedings. He, however, submits that in the circumstance, the petitioner is not duly considered in terms with the mandate of the office memorandum dated 16/3/2024. The petitioner be given the liberty to challenge the same in accordance with law. Mr. N. Angami, the learned counsel appearing on behalf of the state respondent, submits that the office memorandum as to whether the petitioner would be entitled in terms with the office memorandum dated 16/3/2024 is a separate cause of action which has no relevance to the instant cause of action. He therefore submits that the question of granting a liberty does not arise. This court, upon taking into account the above, is of the opinion that the petitioner herein this court, upon hearing the learned counsels appearing on behalf of the parties, permits the petitioner to withdraw the instant writ petition. It is made clear that it is made clear as to whether the petitioner would be entitled in terms with the office memorandum dated 16/3/2024 is a separate cause of action. And if the petitioner is aggrieved for non-consideration of his case, the petitioner would be always at liberty to assail the same.
Much obliged.
Obliged.
For admission, item number 16.
This is a case of premature retirement, Lordship.
This is required. Yes, what is this?
This is a case of premature retirement.
Oh, how did it happen?
Petitioner was appointed in 1988 as L.D. Gum Davis in the establishment of the Advocate General Nagaland at Gauhati, Lordship. And thereafter, his service was extended from time to time. Initial appointment was on contract, and the contract term was appointed. Lordship is well aware about the Nagaland Retirement from Public Employment Act.
30 years.
35 years or 60 years, whichever is earlier. In order to compute 35 years of length of service, government has issued office memorandums from time to time. Now it is settled that if there is break kept in the service, that will not be counted. But even if the initial appointment is ad hoc, contract or work charge, whatever it is, if there is continuation in the service, then the period from the initial appointment shall be counted. But if there is break in service or gap, then it will be excluded from computation of 35 years of service. The government, in my case, all along, the last extension was on 17/11/1989. And all throughout my service career, the government has taken to determine seniority and for length of service, everything. The date of 1989 was taken. Going by that, my due date of retirement is 30th November 2024. However, they have connected my initial appointment and computed the length of service of 35 years, and they have made me retire 30th November 2023, Lord. So that is the short
On 30
matrix. On
30th of June 2023.
Yes.
You had to actually retire from when? As per you?
30th November 2024. In this connection, Lord Chief, this Honorable Court has passed an order on 2nd April 2024. Government has been directed to produce the records.
But is it your case that there is a break in service?
Yes.
When?
My last extension, Lordship, may kindly come to annexure. Let us go to the appointment orders and extension orders, so as to ascertain whether there is break or not.
Then
Page
which one?
24 is the initial appointment.
For 4
It
months.
is 2/8/1988.
Okay.
And the extension order, Lordship, will find it annexure B. In all the extension orders, what is the date? Till what time I have been extended, that is clearly shown in the extension orders. Page 26 will be very important, and this is relevant so as to decide this case, Lord. On 26 September 1989, my service was extended in terms of one order, that is 1989. I'm referring to page 26. And as per this 26 September 1989, the extension was given up to 31st October 1989. In view of this, there is a break of 16 days. And in view of lot of discrepancies, the PNR as well as the law department, they have determined the date as 17 November 1989 as the date for computing 35 years.
Why 17 November 1989? Why is that specific date?
That is the last extension order, Lordship. Can you come to page 27?
Yes, 17/11.
26, I have shown that this extension order is up to 31st October 1989. And 17 November 1989, page 27, annexure C. In continuation to
So
this.
this is the basis on which you say has to be taken into account.
Yes.
27.
Yes, and this was
Now,
taken
where
by
is
the
the gap?
government.
Where is the gap in between? In continuation to the department's order dated 26th of September 2089. What
That is
26?
previous page
Till
26.
30/11, yeah, okay. So there you say the 26th of September was only till 31/10/1989.
Yes.
And as such, it would be, there is a gap of 16 days.
Yes.
Because here they give you, though they give you an extension, but it is appointment of so-and-so is hereby extended. They have given you an extension until further orders from here.
Yes.
So there being a gap of this year, so earlier period cannot.
Yes. In view of this discrepancy, government and in the department, all along, they have taken 1989 as the date of joining this. So that is the whole issue, Lordships. Therefore, and in
And where
the
is the circular of the government that they would,
Indian
as
order.
regards the break?
The
Circular of the government?
government website also shows that my due date of retirement is 30th November 2024. But after filing the writ petition, recently they have changed that also. Indian order is Lordship at page 68. This is the release order. August 2023. It was issued on 17 August 2023 and the effective date of release was 30th June 2023. A retrospective retirement order has been issued.
No, understood, but where is that circular? Circular which says that this, there is a gap in service, you have to be removed.
Lordship, government order have not said anything about the gap.
Then, where, no, where, you are mentioning about some circulars. It must be in the
Or
affidavit.
regarding the government notification pertaining to the gap.
Yeah, you have Annexus 6. Is this the 4th of May 2017?
29 March, there is another order. I am furnishing the notifications, Lordship.
There is another one now, 4th of May 2017, which is Annexus 6 to the affidavit.
Paragraph 6 will be relevant, Lordship. Lordship, the copies which I have placed before your Lordship. There is another latest notification.
Service book, what does it say?
Government affidavit does not categorically reply about the cap and break. They have mentioned only about contract ad hoc. All the service shall be taken into consideration. They have not confined to the break and the cap.
So the case of the respondents is, you see, by 17/10/11/1989, we have extended the earlier contract.
Yes.
And as such, there is no gap. That is this.
Yes.
But tell me, did you get your salary for that period?
No, I have not. I have not.
How do we
Now,
know?
in order to ascertain that
Because that would have a very important aspect.
yes, that is.
Did you get the salary for the period from 1/11/1989 to 16/11/1989? That's the catch.
The extract of the government affidavit, this extract of the service book in the government affidavit, also not very clear how they have computed, how it is calculated. And this period is nowhere mentioned. And there is another order in the extension order, that is 1/9/1989. Through RTI, I have sought for this order.
Where?
The order which I'm referring is paragraph 4, 5, and 8 of my reply has covered all these points, Lordship. Now that Lordship has sent the government affidavit, I have 5 reply and only 3 paragraphs, Lordship may kindly refer to my affidavit in reply. Paragraph 4, 5, and 8.
And Mr. Jamil, one thing very interesting. Kindly come to page 12 of their affidavit.
Government affidavit.
Yes.
Yes.
Against each entry, there's a signature of your client.
Yes.
But there's no signature of your client against the entry for that thing
Particular
which you are
period.
asking.
Yes. Yes.
Because if you see the next page also at page 14, against each entry there is a signature.
Yes.
There's 472, 4AI and everything. But there is no signature in respect to this.
Yes.
So they must be having an order, thereby extending. If they don't have, then there is no extension.
Lordship. That's why, Lordship.
But the question is, whether did you get your salary for that?
No.
You have mentioned anyway.
There is an order of this Honorable Court, Lordship, where this Honorable Court has called for the records. 2/4/2024. There,
produce the record,
the
madam?
government has been directed to furnish the record service book as well as other relevant records.
Madam, we have it.
So as to ascertain the pointed query which Lordship is making. That is relevant.
Regarding that, I have sought an instruction and I've received short instruction, if I may be allowed to please, Your Lordship. Regarding the payroll, Your Lordship. The month in question, Your Lordship, the petitioner has been paid. We are saying that there is continuity, there is no break in service. If your lordship may see the last 5 row of the second page.
Let them produce the original records. It is just few kilometers away from here.
Yes. Madam, you bring this on record by way of an affidavit.
Lordship.
This is relevant.
Lordship.
Because he will also have a right to.
Yes.
Lordship.
And Lordship, there is also an order on 2nd of April 2024. Government should comply with this order also. Besides the affidavit which your lordship is inclined to direct.
I'd Mr. C.T. Jamid, the learned senior counsel appearing on behalf of the petitioner, and Ms. S. Mary, the learned senior government advocate appearing on behalf of the state respondents. The issue involved in the instant proceeding is as to whether the petitioner 35 years of continuous service should be counted with effect from 26/1988 or from 17/11/1989.
Yes.
Inasmuch as it is the specific case of the petitioner that by order dated 26/9/1989, the services of the petitioner was only extended till 31/10/1989. Thereupon, there was a gap in service, and it was only on 17/11/1989 the services of the petitioner was extended until further orders. On the basis thereof, the case of the petitioner is that the petitioner ought to have retired on 30/11/2023, 24, and not on 36/2023, which by 12 of the year. And as such, have they challenged the premature retirement of the petitioner by the respondent authorities. It is relevant to take note of that on 2/4/2024, this court had directed the state authorities to keep the personal service records of the petitioner to verify as to whether there is break in service of the petitioner prior to 17/11/89, or the petitioner continued to serve the state with effect from the initial date of appointment dated 26/1989. In pursuance to that, the matter was taken, in pursuance to that, the learned counsel, Ms. S. Mary, the learned counsel appearing on behalf of the respondents, have placed an instruction dated 8/5/2024, along with the salary roll for the month of September 1989. It is the categorical statement, a categorical case of the petitioner, of the respondents, is that the petitioner herein have received the salary for the entire month of September 1989. Month of September 1989. Full stop. Be that as it may, this court, be that as it may, the question, however, arises is as to whether the petitioner have received the salary for the month of November 1989, which has, however, been not placed on record. Inasmuch as if the petitioner have received the salary for the month of November 1988, a different aspect of the matter would arise. Taking into account the above, the matter, list this matter again on 4th of July 2024. On the said date, the salary roll for the month of November 1989, for the month of, so on that day, listed on 4, on or before 2nd of July 2024, the respondent authorities shall file an affidavit bringing on record the salary roll in respect to the petitioner for the months of September 1989, October 1989, as well as November 1989. In addition to that, the original service book of the petitioner. It's with you now?
No.
No, it
it's
is not.
with me.
This court further directs the petitioner to also produce the original service book. It's with you.
No, it's not with me.
It is to be with you. You have only the person.
They are the custodian of the service book.
After you retire, it is given back.
It will be with the petitioner, Your Lordship. It will be with the petitioner because he has
Pension has
already
not been
retired.
processed yet.
Huh?
In view of pendency of this, it's pending.
On the next returnable date, on the next day, the parties herein are directed to place before this court the service book of the petitioner in origin.
Lordship has chosen a very auspicious day, 4th July.
Oh, yes. That is why I fixed the matter. America got independence.
For admission, item number 17.
Please, my lordship,
Yes,
this is just a
madam.
compassionate appointment. The petitioner's husband died leaving behind 9 dependents, 7 children, and the
Yes. What is her status in the rule?
She
Serial
stands,
number?
the petitioner stands at serial number 4, Your Lordship.
Serial number 4?
Yes, Your Lordship.
No, lordship, I want to contradict that. What has happened is the scheme is 50%. My lord will kindly come to page 15, annexure E.
Annexure ERF.
E, clause 4.
Yes.
This is the scheme.
Hmm.
Now, before it was 5%, but now the state government has raised it to 50%, lordship. Compassionate appointment may be made to the post falling under the combined direct recruitment quota of group C or D. The ceiling for compassionate appointment of 5% of the direct recruitment vacancy in group C and group D posts has been done away with. Provided such appointment do not exceed 50% of the vacancy during a year. The appointment against posts for direct recruitment in group C should be in the entry only. Further appointment against any post for direct recruitment in group C should be limited to those posts which are outside the purview of the NPSC. Now what has happened is, lordship, basing upon this, I submitted my application. My husband died on 16/10/21. My application is 10/12/2021. After then, What has
Yeah, no,
happened
no, your
is,
husband died on?
Lordship,
Your husband died on
16/10/21,
16,
16,
10, 2021, and your application is of
10/12/21.
10, 12, 2021.
Yes,
Okay,
Lordship.
then,
Then I submitted my application and then they issued this 17, serial number, page 17, annexure F in the repetition.
hmm.
My lord, the readout, type out is at page 18.
What is
So-
your name?
No, I found this out, so I applied for RTI.
Atukoli Aumi. Okay. Where are you? You are not here.
I was not here. So those who relatives expired prior, after me also were included. So I filed an RTI. Then what has happened is that this happened to be in their affidavit in reply. They say that it is only that grade 3 post, whereas I applied for grade 4. Now what has happened,
What
the
did they say?
modus operandi is,
The deponent admits that the approval of 12 person was made to waiting list in the corner in respect to Iman as per Iman.
so I filed an RTI in my affidavit in reply, Lordship. I have annexed all the documents.
So they say these persons are from grade 3.
Yes, grade 3. What has happened is now this grade 3 post comes under NSSB, recent 2 years back, NSSB. So under this, those posts that has to be sent to NSSB, they are appointing compassionate appointment that is in grade 3, 12 has been appointed because the posts belong to NSSB. So they are immediately appointing. However, no grade 4 was shown here. That's why I filed my RTI and my lord will kindly come to affidavit in reply. So this is page 4.
Now there is one document which I furnishing RTI.
Yes.
22nd of September 2023.
Yes.
Yes.
The first application is in my affidavit in reply, Lordship, page 4, annexure 1. This is the application.
First application is of 2018. Leela Sang. You are number 9.
No, Lordship. Where is my Lordship? Annexure 1A, page 5.
Yes.
This was again filed on 15 January 2024. I filed 2 RTI, Lordship.
1A is this. This is 15th of January. This is of 22nd of September is another one. This is different, no?
This is different.
Okay.
So the last one I filed 15 January 2024. Then page 6, annexure 1B is the query, the reply. What has happened is I asked for grade 4 vacancy post arisen in the department with effect from 1/5/2015 till November 2023. Then number of appointment made in grade 4 post with effect from 1/1/2015 till November 2023, showing mode of appointment, general compassionate landowner, whether government approval or through advertisement. Then 3 is number of future vacancies. That will arise in grade 4 post showing the date of retirement of employees till December 2025.
You are reading or you are asking for these? Okay.
Yes.
What is it?
7 is annexure 2.
Okay.
What has happened is, Lordship, these are the vacancy arisen after 2015. So my lord will kindly see 15 to serial number 25. That is prior to my husband's expiry. Serial number 1 to 25.
Okay.
That was prior to my application, Lordship. Starting from 26 to 49. These are after they have appointed 24 in grade 4 post. After my application, 24 post. So what has happened is, Grade 3 is NSSB post, that's why they are appointing a compassionate appointment as per the scheme. Whereas in grade 4 post, they have not appointed even as per their response, those whose relative
So they
died.
have not appointed anybody on compassionate grounds.
Yes, and they
All are
are,
general appointment,
they are
which
doing,
is not in terms with that particular
yes,
clause of the.
exactly.
That's the
So
case.
as per the term of the scheme, if 24 appointment has been made, if I am at serial number 4, if it is divided, 12 posts belongs to the compassionate appointment, Lordship. So they are not appointing, and grade 3 post, NSSB post, that's why they are appointing. However, grade 4 posts, they are appointing their pick and choose policy. This is the case, and
what
here
is-
are the
and what
documents.
is page annexure 4, number of future bills that will arise in year until September year. So.
All are government
then
approval, there
also,
is no
these-
advertisement.
These are many vacancies which are arising.
Yes.
What do you want to do now?
Your Lordship, I respectfully submit that as.
No, he's in
Yes.
serial number 4.
Yes, yes.
We are not going to touch whatever appointments which have been made, although it is contrary to your office memorandum. We are not going to touch it. But the fact is, the petitioner hearing can't keep it because it's a case of a compassionate appointment.
Yes, yes.
A compassionate appointment is, as per the Supreme Court judgments, is to take care of the immediate need, and as such, you have this compassionate appointment. A very long delay does not make anything. It is only in the state of Nagaland you have a particular scheme which you give it as serial life. In fact, this is a very good scheme for that, but it goes actually against what the Supreme Court recently had said, that it is not a source of recruitment, and it does not also confer a vested right. Supreme Court said, but you have conferred a vested right on the basis of your scheme. A right is being conferred on the basis of a scheme that you are going to consider. You are going to have 50%. But whatever, less than 50%, but you cannot. From 2022 onwards, you have not given any compassionate appointments.
Exactly, Lordship.
Now, there are vacancies which are to reason.
Yes,
You have to take care of it.
Yes, Your Lordship.
So if you have not done it, do something for that. How do I further proceed with this matter?
Your Lordship, in regards to that, I have instructions to inform the court that as per their RTI, which is in page 11 of the reply, that is the list of upcoming vacancies.
These are the new vacancies which are arising.
Yes,
In fact,
so-
3 are already arising.
Yes, so since the petitioner hearing lies in number 4.
Lordship, had others been appointed in 12 posts, I am already within the 12 posts belong to not only me, but compassionate appointment. They are not appointing even one, Lordship. So
as per
the
this
immediate,
So you mean to say till 28 to 2025, the petitioner cannot be appointed?
Yes, as per the upcoming vacancies, Your Lordship, the petitioner will be most likely considered on the
No,
retirement of
understood, that is
7
okay.
and 8.
no,
Against these vacancies, you are again going to apply the 50% rule.
That is the instruction that
Then
I
if you
received.
do that, what happens to the earlier, if you have done it, in fact, it's the roster point like, you have already, there is a backlog. How are you
yes,
going to take care of that?
The backlog, Your Lordship.
Backlog, isn't it? You were supposed to
24 already
appoint from
appointed, 12 already
2022, there are
is
various
backlog.
vacancies which have arisen.
Yes.
In fact, from 2022, if we see till date, from 2022, okay, from 2022, from page 26,
Yes.
serial number 26 to 49,
Yes,
means you have already appointed 27. 26 to 49, 23 appointments, without following what is required, less than 50% also something. So there is an accumulation or a black clock which is occurring.
Yes.
Now, how do you take care of that? You get the point?
Yes, yes.
How do you take care? Now, if you again apply that, she would never get an appointment.
Yes,
till,
Lordship.
if we go by this thing, You may not give her appointment till 36/2025
Exactly, Lordship.
by again applying the 50%. How do you take care of that situation?
The first one, father died in 2013. Even 2013 is not being provided. This is unfortunate.
My lord, let me supplement my colleague. 24 appointments as per the IRT Act. Your lordship can see and appointment, it is only appointment, as my learned friend has said. In what category? Because compassionate appointment is on regular basis. Is on regular basis. Lordship may kindly see page 15 of the writ petition. Page 15 of the writ petition. This is the scheme. Para 3. Appointment on commissioned ground shall be made only on regular basis to direct recruitment. So, your lordship, what I'm supplementing is that my friend has only given, as per the IRT 24 appointment. In what category?
Grade 4, I asked for grade 4 post.
That is okay, that is okay. But whether they were in auto, casual, because
It's a regular appointment, so it will be regular appointment. What casual you are
lordship,
talking about?
please appreciate the stand of the state also, because in order to appoint on a regular basis, there has to be clear vacancy.
That's why.
Because creation of post is banned in Nagaland. There has to be
Oh my
regular
God.
vacancy. So my friend is saying, I admit to that 24 appointments was made. But on what basis? My friend failed to show that. Because regular, it should be regular appointment. When there is a regular appointment, even whatever the grade 4, okay. But there has to be clear vacancy. Someone might have retired, or there has to be clear vacancy, sanctioned post, even for grade 4 also. So there is the question.
No, these
Your
are sanction
Lordship.
posts which are there in her affidavit in reply. You see, what has happened is this. A particular, she applied in the year 2021.
Correct.
She is at serial number 4 as an admitted stand of the respondents. Now, from 2021-22 onwards, there has been various vacancies. And all these vacancies, 23 vacancies, have been filled up by direct recruitment or on the basis of land ownership. So these appointments have been duly done, meaning thereby, from 2022 till 2024, there have 23 vacancies have been already appointed against vacant posts, regular vacant. These are
Yes,
regular recruitments.
exactly, Lordship. 24, Lordship.
Now, what is happening is this. There is no maintaining of that less than 50% also that has not been maintained.
Not maintained.
So, if that is not being maintained, now what is happening in 2024, there are 3 vacancies which are arising.
Yes.
And 2025, there is 1 vacancy arising and many vacancies arising, and most of the vacancies are arising on 36/2025. Now the question, therefore, I put the question to your esteemed colleague out here. Then look here, if you are now going to, don't you have a backlog? Or are you still going to apply the 50% rule? If you do it, meaning she can't get any appointment in 36/2025.
We are going to apply.
So
Because
something has to be done on that basis. Because if you don't do it, because you have not followed the backlog, the rule in respect to those 23 appointments or 24 appointments,
Correct,
you did not.
absolutely.
And now if new appointments, do you have the system of, which you otherwise have for SC/ST thing, a backlog vacancy? A backlog vacancy, how do you appoint? Are you going to attempt to do that? So that is what I was asking. So therefore, the appointment, she would be entitled to the appointment, but the question is, as of today, she can't get an appointment. The earliest of the appointments she can get is on 30/4/2025.
Yes.
And the next appointment, if she gets it, is on 36/2025, when there is a vacancy rising. But if you are going to apply that rule, it's gone for a 6, because that means you need minimum 8 vacancies.
Yes.
And all these
Let me come back.
appointments,
I think, think about it. We'll pass an order to that effect. That taking into account, because she will otherwise get it by 36, if I'm not wrong.
Yes,
Because
36,
she gets it by
36,
36.
2025.
If we apply the 50%.
Yes, Your
Because 36, there are 12 vacancies.
12 vacancies.
Lordship,
So
I
by
just,
then she gets it.
Yes, Your Lordship. That is the,
Lordship, the backlog should
that is
be
a instruction from the
considered,
authority.
otherwise it
No,
will just go
backlog,
on
no.
like that.
She has
It is
not
what? If
challenged,
the backlog is also considered, it is 34. You get only 2 months before at best.
No.
Just think about it. Don't you think that this will be better, a safe option to have it 36 after 2 months and get them done against those 36? Let me come back.
Lordship,
Lordship.
obliged, Lordship.
Still live. to dispose of
Lordship.
on the basis of the materials.
I just pray that, Lordship, this serial number 1 is 2013. And my Lord, in your wisdom knows that it is for compassionate appointment is for immediate financial assistance. And now it's already 11 years, the first one. So
Let us not go into that aspect of the matter. If we
Lordship.
go to that aspect of the matter, it will touch upon the compassionate appointment scheme. Because otherwise, if we go by that, those judgments, it really affects the compassionate appointment scheme, for which I think it would not be better for this
Lordship.
court. It will have
As best
far-reaching
as my Lord,
consequences upon many.
as best as my Lord thinks that the respondent won't take advantage or
The
again
226
deviate from.
jurisdiction, the jurisdiction under Article 226, the jurisdiction under Article 226 of the Constitution have been invoked by the petitioner, being aggrieved by the non-consideration of the case of the petitioner for being appointed on compassionate grounds in terms with the office memorandum dated 17/9/2015. The facts relevant for the disposal of the instant writ petition are that the petitioner's husband was serving as the storekeeper at Cessors, Chessor, under the establishment of the Assistant Director, Food and Civil Supplies, Tuan Sang. He died in harness on 16/10/2021. Thereupon, immediately, the petitioner on 10/12/2021 applied for being appointed in terms with the office memorandum dated 17/9/2015. However, as the respondent authorities have not taken any steps for consideration of the case of the petitioner has therefore approached this court by filing the instant writ petition. Before further proceeding, this court finds it relevant to take note of the office memorandum dated 17/9/2015. A perusal of the said office memorandum shows that the appointment on compassionate grounds shall be given only to one of the following members of the deceased family, deceased employer's family. It would be either the spouse or the son or the daughter. It is also seen that the appointment on compassionate grounds shall be made only on regular basis to direct recruitment post and only if regular vacancies meant for that purpose are available in that department where the deceased government employee was serving. Clause 4 of the said office memorandum has great relevance to the instant proceedings, inasmuch as the earlier ceiling for compassionate appointment of 5% of the direct recruitment vacancies in Group C and Group D post was done away with, thereby providing that such appointment on compassionate grounds shall not exceed 50% of the vacancies during a year. It has also been mentioned that the appointment against post for direct recruitment in Group C should be in entry grade only. Upon filing of the instant petition, the respondents filed their affidavit in opposition, wherein it has been stated, amongst others, that the petitioner's case is still under consideration in the chronological order for appointment to grade 4 post on compassionate ground under the Department of Food and Civil Supplies, Nagaland, and the petitioner's name is, and the petitioner stands at serial number 4. It has been also mentioned that the case of the petitioner for appointment to grade 4 post on compassionate grounds shall be considered as and when her turn comes, subject to availability of vacancy. To the said affidavit in opposition, an affidavit in reply has been filed. A perusal of the said affidavit in reply shows that the petitioner have taken the stand pursuant to obtaining certain information under the Right to Information Act 2005, that the authorities have not adhered to clause 4 of the office memorandum dated 17/9/2015. From the said enclosures to the affidavit in reply, it is seen that 48 vacancies had arisen in grade 4 post in the Food and Civil Supplies Department during the period from 2015 to 2023.
49 vacancies.
49 vacancies.
Yes, one.
And it is also pertinent to mention that "24 vacancies have arisen pursuant to the filing of the application by the petitioner. It is also seen from the said enclosures that since 2015, as many as 49 appointments have been made. Thereby, all the posts which had arisen from 2015 to 2023 have been filled up. Interestingly, "24 posts have been filled up since 21/11/2022, either by direct recruitment or on land ownership basis."
Lordship, there is no direct recruitment, all without advertisement. All appointed without advertisement. General land ownership is only one.
From here, it is not known, na?
Yeah, no advertisement at all.
No, you see, there are 2 posts. One is direct recruit, who, when you enter the feeder cadre, it is direct recruitment. So they may not be in due process, but wouldn't that be a direct recruitment? It is, but without due process.
Yes, without due process.
This court at this stage also finds it relevant to take note of the submission of Ms. Jed Zimomi to the effect that these direct recruitments which have been made since 21/11/2022, or for that matter, 22 direct recruitments have been made without following the due process. Be it as it may, one aspect of the matter is clear, that the said appointment, the said vacancies which have arisen from 2022 onwards have not been filled up by way of, said vacancies have been arose since 2022, have not taken into consideration Clause 4 of the Office Memorandum dated 17/9/2015. It is also seen from the said enclosures that for the period from 2024 till 2025, as many as 13 vacancies are going to arise, starting from 31/1/2024 to 30/11/2025. Footstep. The Learned Counsel, appearing on behalf of the petitioner, submits that the petitioners, therefore, ought to be accommodated against the vacancies which are to arise, in the initial part of 2025, that is on or before, that is the vacancies. Now, the Learned Counsel, appearing on behalf of the petitioners, therefore submits that the petitioner, therefore, is to be, the case of the petitioner, therefore, is to be considered for compassionate appointment on the first of the 4 vacancies which are to arise, taking into account that the petitioner is at serial number 4.
So, Lordship, if I may, first of the 8, since it will be 50/50, as per clause.
That is her submission.
Oh,
I didn't say.
apologies, Lordship.
Footstep. On the other hand, the Learned Counsel, appearing on behalf of the respondent, submits that if any direction is given to that effect, it would violate the mandate of Clause 4, which permits not more than 50%. I've heard this court have duly heard the Learned Counsels appearing on behalf of the parties and have given due consideration to their respective submissions. From the materials on record, it is clear that the petitioner herein is entitled to be considered in terms with the Office Memorandum dated 17/9/2015, inasmuch as it is also the admitted fact on the part of admitted by the respondents in their affidavit that the petitioner is at serial number 4 of the list in the chronological order, and she would be duly considered when her turn comes. This court have also taken note of that the respondent authorities, while making 24 appointments during the period from 2022 to 2023, did not at all adhere to the norms as set out in clause number 4. Inasmuch as no appointments were made on the basis of compassionate grounds, or for that matter, the office memorandum dated 17/9/2015. Be that as it may, there is no challenge to those appointments, and as such, this court would not further delve on that issue. However, it is seen that from Annexure 4 to the affidavit in reply, that 13 new vacancies are going to arise, of which 12 vacancies are arising on 36/2025. Under such circumstances, it is the opinion of this court that the petitioner therefore is required to be considered and accommodated in terms with the vacancies which are going to arise on or before 36/2000 in respect to those vacancies which are to arise by 36/2025, on 36/2025. Therefore, this court disposes of the instant petition, directing the respondents to consider the case of the petitioner in terms with the office memorandum dated demand 17/9/2015 and accommodate the petitioner in terms with the said office memorandum in respect to those vacancies which are to arise on 36/2025. With above, the instant petition stands disposed.
Lordship.
Because 2 months here and there makes no sense.
Lordship, here, just my one humble submission.
Yes.
Since they have not given even one appointment to compassionate appointment, the future vacancy that is going to arise from this 24 onward, why can't that backlog, since they have not appointed the previous one, this be accommodated to compassionate appointment? That is my.
I understand, but this is only a period of 3 months. 3 months is the difference because all are arising on 36 maximum. First 4 is okay. Then thereafter you have from 36.
36 also is arising, one is arising.
Therefore, all these 36 are arising till
24.
No, to 2024 there is no vacancy, only 3 vacancies.
3 vacancies.
That vacancies you can't get in. So you can at best get in if we consider the backlog by 28/2/2025. That's the 4th vacancy. So the next vacancy, till thereafter, 8 people are retiring on 36/2025. So therefore, you are to be accommodated without going to all these things. Because if I say anything to that effect, then they will again come up in appeal or something. Now they can't.
Lordship. Obliged, Lordship.
For admission, item number 18.
Yeah, please, Lordship. Lordship, I beg to mention on behalf of Thepapong, Lordship.
Hmm.
If kindly 3 weeks time may be granted to me, Lordship.
What is the matter about?
Your Lordship, this is about regularization of service of the petitioner.
Which office memorandum?
17/3/2015.
You completed 30 years.
35 years.
You have completed.
Yes, Your Lordship.
Then why they
I
are not
retired.
considered? You were appointed on 14/9/85.
12/9/1985.
When were you retiring?
30/9/2020. I was retired.
30/9/2020.
Yes, Your Lordship.
And you complete 35 years.
35 years.
So you gave this representation, they have not considered.
Yes, Your Lordship.
And therefore they are to do. Yes, why you have not done it?
Lordship, if some time may be granted, Lordship, if I'm not gone,
Huh?
Lordship.
that counsel who is there for the respondent, every time you are asking so much of time, what to do? Put on the fan, it's pretty warm out there. No? Chalo. You consider, and I dispose it of, consider his case in terms with the office memorandum if he picks him. Because there's nothing out there. He says that he has been appointed. You consider if he's there or not, he's entitled or not, and then dispose it of. And grant him within 3 months, 4 months.
Instructions.
Huh?
We need some instructions.
What instruction? Instruction will be what? If you give, just for example, you give me an instruction, yes, he's entitled to. What can I do? I can only ask you to consider. Can I ask you to appoint? I have no power to that. So here is a case where his case ought to have been considered on or before his retirement. Yes. He's retired. Do something. Otherwise, he's not getting a pension. We're getting pension.
Oh, yeah.
Then can't help it. You have not filed your affidavit, so much time given. This can't happen like that. The petitioner herein have invoked the jurisdiction of this court under Article 2 to 6 of the Constitution, being aggrieved by the inaction on the part of the respondent authorities to grant the petitioner the benefit in terms with the office memorandum dated 17/3/2015. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and so-and-so appearing on behalf of the state respondent. It is the case of the petitioner that the petitioner was appointed on 12/9/1985 as work charge carpenter helper under the establishment of subdivisional officer PWD Kifri, subdivision Nagaland, in the scale of pay of rupees 375-445-9-10-590 per month, plus other allowances admissible from time to time. The petitioner, on completion of 35 years of service, was released on 30/9/2020. It is a case of the petitioner that the petitioner is entitled to be regularized in terms with the office memorandum dated 17/3/2015, in as much as the petitioner completed 30 years of continuous service on
12/9/2015.
huh?
12/9/2015.
12/9/2015. 2000?
30 years. 2015.
2015.
Yes, yes, yes.
11/9/2015.
12/9/2015.
12 is the first day. The last day has to be 11. You complete on that date, na?
Okay.
On 11/9/2015. However, the case of the petitioner have not been considered, although it is the mandate in terms with clause 1 Roman 2 of the office memorandum dated 17/3/2015, which stipulates that in respect of those workers and casual employees in scale of pay and who have completed or will complete 30 years of continuous service after 1/1/2015, their cases for regularization will be taken up subsequently in 2 batches as on 1st of July and 1st of January every year. It is the case of the petitioner that the respondent authorities have not taken into consideration the case of the regularization, the entitlement of the regularization of the petitioner as on 1/1/2016. You complete on 11/9/2015.
Yes, Your
So it should have been done in the 1st of January 2016.
Yes.
And therefore, the petitioner had submitted a representation which have not also been, to which the respondent authorities have turned a deaf ear. It is under such circumstances the instant petition was filed. This court duly takes note of that by an order dated 12/9/2023, notice was issued. It is seen that the respondent authorities have sought for adjournments for filing the affidavit in opposition on 12/10/2023, 6/11/2023, 12/2/2024, 5/3/2024, 2/4/2024, 18/4/2024, as well as on 13/5/2024, but have not filed the affidavit in opposition. This court also takes note of the submission made by the learned counsel appearing on behalf of the petitioner, that the petitioner is the petitioner's right to life and livelihood have been taken away, in as much as the petitioner case, if due would have been considered for regularization, the petitioner would have been also entitled to pension. However, in view of the actions of the respondent authorities, the petitioner have been deprived from the pension, and for the last 4 years, the petitioner have been deprived. Under such circumstances, the learned counsel appearing on behalf of the petitioner expresses great urgency. This court, having taken note of the materials on record, and also to the fact, and also upon perusal of the office memorandum dated 17/3/2015, is of the opinion that if the petitioner was duly appointed on 12/9/1985 in the scale of pay and have been granted the scale of pay, the petitioner is entitled to be considered in terms with the petitioner's case ought to have been considered by the respondent authorities as far back as on the 1st of January 2016, in as much as the petitioner duly completes 30 years on 11/9/2015. Taking into account that the respondent authorities have not complied with the said mandate of clause 1 Roman 2 of the office memorandum dated so and so, this court therefore disposes of the instant writ petition, thereby directing the respondent authorities, and more particularly whom should we direct? Then only you can file a pinpoint.
Respondent number 3.
Respondent number 2 and 3 to take appropriate steps in terms with clause 1(2) of the office memorandum dated 17/3/2015, and so that the petitioner's case can be duly considered for regularization as on 1/1/2016 and this court further observes and directs, further observes that the instant writ petition has been filed. The above order is above order. The instant order has been passed on the basis of the statements made in the writ petition that the petitioner was duly appointed on 12/9/1985 in the scale of pay. The respondents have, however, not filed an affidavit. And as such, the respondents would be within its jurisdiction, within its authority to verify the said aspect of the matter. And upon verification, if it is found that the petitioner was duly appointed on 12/9/1985 in the scale of pay and being granted the scale of pay, the petitioner herein would be entitled to the benefits in terms with the office memorandum dated 17/3/2015 and upon regularization to other service benefits as mandated in the law. The said exercise be completed by the respondent authorities within 4 months. Today is what? We are in the month of June.
Yes,
Within 5 months. 5 months. From the date a certified copies of the instant order is served upon the respondent number 2 and 3. Okay.
Much obliged.
For admission, item numbers 19 to 21.
Your Lordship.
Yes, what is this?
Your Lordship, kindly grant us a week's time to file a reply.
Why? Don't want to do the matter before me.
No, Your Lordship.
Why? She even confesses that she doesn't want to do the matter.
No, Your Lordship, just 1 week's time, Your Lordship.
Why? Scheme of what?
2004 and 2015.
This has already been upheld by the division bench.
Lordship, both the two schemes are still in existence, Your Lordship.
Huh?
In existence, Your Lordship. The 2004 and 2015 is still in existence.
Understood. No, in
Yes.
fact, it has been upheld by the division bench
Yes,
in
Your Lordship,
writ appeal 6 of
yes,
2022.
yes,
So how
Lordship.
can now you challenge this? This covered.
Your Lordship, in the earlier similar case, Your Lordship has directed me to file an affidavit whether the two schemes are still in existence. I had already filed my affidavit that.
Which
yeah,
one?
The OM 2004 and 2015, Your Lordship.
Ah.
Yes. Your Lordship has directed me.
So should I fix this matter on 13/6? That day, the chief, the advocate
Lordship,
general is
on-
appearing.
On 13, I don't know. It may be a
Because today there
difficult-
were, you must have seen,
Yes,
the
yes,
advocate general.
Lordship, yes, yes.
So there that issue is there.
Yes.
Because that order seems to be in conflict with the division bench order, wherein it says the division bench categorically says that 2015 AR is valid and 2004 shall remain in force, shall be only applicable unless it is not contrary to 2015.
So that 2004 in this particular case also is not in conflict, Your Lordship, because 2015 relates to scale of pay, who has completed 30 years, and 2004 relates to fixed pay and scale of pay, Your Lordship. When there is a 50 vacancy, they will be accommodated in that 50% vacancy, Your Lordship. Yes.
So understood.
So, Lordship, in that case, my learned friend is going to file a reply. So,
Who?
Lordship,
You want to
if
file
you
a
my
reply?
affidavit, in reply to my affidavit
Yes,
in
Your Lordship.
opposition, Your Lordship. Yes, she is seeking
What is
time.
there to file reply?
Yes.
Hello? What is your affidavit in opposition say?
My affidavit, I'm saying that he is a fixed pay employee.
Hey,
So he
there I
cannot
have
challenge
kept
the-
one paper, okay, where is that? I said that will be required. The office memorandum of 2021 or 24, where is that 16 months? I kept it here. No? Huh? No, I kept it here. No? I said it will be required. What has happened to this 2021, 24 office memorandum?
The 24 relates to the regularization of contract and court appointee. who
Not
are-
them.
No, who are holding sanction posts. Here is relates to work charge employees.
These are
who-
work charge.
Yes, yes. Who are
And
not-
they are in fixed pay.
Yes, the petitioner, item number, item number 19 and 21, they are fixed pay employees. So they cannot challenge the OM 2015 because they do not have the locus.
So they can't come under 15.
Yes, they don't come under 15, and their case can be considered under 2004. But their serial number stands as 96 and 97. Their seniority, Your Lordship. Because in Nagaland, Your Lordship, we have more than 10,800 plus workers employees, Your Lordship. So we maintain seniority, Your Lordship.
Madam, we do one thing.
Yes.
Whatever reply you have to file. If it is on 13/6, when that the Advocate General appears in the other matter.
Yes, but Your Lordship, I have a reservation that I will be assisting AG on 12. So if in principal seat, if that case continues for 13, because there's.
Where in the principal seat?
Yes, on 12th of June. So that matter hearing, it may continue on 13 also. So there is a.
We'll accommodate you.
Okay, Lordship, Lordship.
Let us fix this
Okay,
matter
okay.
with that, because this will be
Okay.
also touching on that
Yes, yes,
regularization.
Lordship, Lordship.
What does he have to say? You
Yes,
may just inform the AG
Lordship,
about
Lordship.
these. This is another set of matters.
Sure,
Let him come up,
yes.
because he has said that he would like to review the aspect and then make
Yes, yes,
submissions
Lordship.
as to whether 2004 remains, 2015 remains and all.
Yes.
Because after all, when the AG makes a statement before the court, it is binding on the state,
Sure, Your Lordship.
which may not be with you,
Yes,
but
yes.
it is binding when the
Yes,
AG says.
yes, yes.
Taking into account that these three matters pertain to challenge made to the office memorandum, to certain clauses of the office memorandum dated 22/9/2004 and 17/3/2015. This court directs the registry to list this matter along with, what is that item which I took up, first item, na? When the AG had appeared, which item was that? Huh? 9? Na? Yes.
Yes, item number
With
9. Lordship.
WPC number 275/2022 on 13/6/2020. In the meantime, the petitioner would be at liberty to file the reply if so.
Particular.
For admission, item numbers 22 and 23.
Yes, what are these? Construction,
Lordship.
non-payment of dues.
Yes, Lordship.
What happened? What is your case? How much you are entitled to?
Lordship. First running bill has been released. Out of rupees 11 lakhs and 11,000 Lordship. The work orders for value of 40 lakhs.
So now you are asking for 29
29
lakhs. What do they say in the affidavit?
They have finished a report, inspection report.
Now, did you complete the work?
Yes, Lord.
They say that they have not completed the work.
As per the drawing, Lordship, that is what it is.
They categorically say that the work has not yet been completed. Yes, madam. Isn't that your stand?
There is a violation of the terms and conditions. It was not executed as per the plan. And Your Lordship, this project is under PIDTC scheme, which is 100% fully central fund, Your Lordship, by the Ministry of Tourism, Your Lordship. It has been delayed due to change of guard at the central, Your Lordship. So, Your Lordship,
There are two reports, Lordship.
Now you are saying that it has to do with the central government funding.
Lordship,
But
because it's 100%.
where is it
funding.
mentioned anywhere that this has to do with anything with the central government in your communications to them?
Your Lordship, communication by the director to the state government. Your Lordship,
These
that
are
I-
okay, but
Yes,
how
sir.
will he know that you have anything to do with the central government?
You'll see the letter of the Ministry of the.
No, that is subsequent. But how will he know when you have entered into an agreement with him or whatever, that this is a central government project and depends on the funding of the central government?
Lordship.
How will you give me a good idea?
I'll have to seek instruction from the department as to whether there are some materials to show.
Both the cases similar?
Yes, yes.
Same party?
Yes, sir.
Yes.
It appears, one order. The petitioners in both the petitions are the same. And the petitioners are aggrieved by non-payment of the, non-release of the remaining amounts due to the petitioner, even after the petitioner having completed the work. The respondents, however, deny that the petitioners have completed the work. Be that as it may, it is seen from the enclosures to the affidavit so filed by the respondent that that pursuant to the representation submitted by the petitioner, the respondent authorities have given a reply. In the same reply, it is seen that the said amounts have not been paid to the petitioner, in as much as there has been no release of funds by the Ministry of Tourism,
Yes,
Government
yes.
of India.
Yes, yes. Your Lordship.
This court, under such circumstances, had put a specific query upon Ms. S. Mary, the Learned Council's senior government advocate, Government of Nagaland, as to whether there is any document which would show that the petitioners were duly informed prior to entering into the contract that the project or the contracts are being awarded on the basis of fundings by the Union of India, by the Government of India. The learned senior government advocate seeks for some accommodation. List the matter again on 5/7/2024, on which date the learned government advocates shall produce the instructions.
Item numbers 24 to 26.
Yes, Mr. Joshua, tell me what is your case?
Your Lordship.
Oh, you are the other
Yes,
side.
for the private respondents.
Yes, tell me, what is your case?
Your Lordship, we have received the counter filed by the state respondents and private
Land
respondents.
ownership department.
Yes.
Land
Sure,
ownership basis.
Basically, my lord, my case is that they have already received 2 appointments on the basis of land ownership. And the state notification is against them that it cannot be in perpetuity. So my preliminary objection is that they have no case.
Your case is in view of 3C. Clause 3C of the land agreement that
Yes, your lordship.
3C,
Yes,
wherein
your
it says that it cannot be in
In
perpetuity.
perpetuity. And they have already received 2 appointments.
Already got appointments.
Yes. And in fact, even the land compensation also has been paid to them. In addition to that, they have already received 2 appointments.
We would not like to, Mr. Joshua, see the state of, he's not prepared.
My lord, I will not insist, especially when she's a new council and her senior is not there.
Yes, now tell me when.
Your Lordship, we received the counter filed by the state respondents and private respondents. Therefore, 3 weeks may be granted to file affidavit in reply.
You want to file an affidavit in reply. When did you receive the affidavit in opposition? Well, it was filed on 8/5/65. You already got enough time, 10/4. What do you mean? Thing? The council appearing on behalf of the petitioner seeks how much? 3 weeks time for filing their reply to the affidavit in opposition filed by the official respondents as well as the private respondent in all the 3 matters. It is seen that the affidavit in opposition of the private respondent in all the 3 matters were filed on 10/4/2024, and the affidavit in opposition was filed by the state respondents on 6/5/2024. On the earlier occasions also time had been taken. Under such circumstances, for the ends of justice, this court grants time to file their affidavit in reply by 3rd of July 2024. The matter be listed again on 8th of July 2024.
Lordship.
For admission, item numbers 27 to 29.
May I please, ma'am?
Yes.
Lordship, in this matter, I have received the Paraguay's comment. However, your Lordship, I have sent a letter seeking certain clarifications pertaining to the Paraguay's comment. Now, what happened is, your Lordship, the petitioners herein are seeking the payment of their pending salaries. Now, in the Paraguay's comment, the department have said that because of the ghost employees, etc. There was
it is because of the verification.
Yes.
All the 3 petitions have been filed by the petitioner being agreed by the non-release of their salaries since June 2021.
Till date.
Huh?
With effective from June
Till
2020.
date. Since June 2021. Mr. N. Angami, the learned counsel appearing on behalf of the state of Nagaland, submits that on account of certain verifications being carried out, the petitioner's salary have not been released.
Lordship.
This court is of the opinion that a verification cannot be permitted to continue in such a manner that an employee have been rendered an employee's right to life and livelihood is being taken away in as much as since the salary, the employee's right to livelihood would be affected, which violates the mandate of Article 21 of the Constitution, apart from being in violation to Article 14 of the Constitution. Accordingly, this court directs the state respondents to complete the verification insofar as the petitioners by 28/6/2024 and file an affidavit by 2nd of July, 4th of July 2024. The matters be listed
May I
on
please, my
8th
lord?
of July 2024.
Lordship, the 28 by 2nd of July, Lordship, if some
I'm
accommodations
giving
may be.
you 4 weeks. You have to only complete your verification.
Yes, my lord.
And I'm not asking you to release.
No, no.
I'm not asking. Complete the verification by 28.
Yes,
File your affidavit by 4th,
yes.
fixing the matter on 8th.
Lordship, there certain accommodations be kindly be given to me, Your Lordship, for the fact that, Your Lordship, I am taking out my father for his review treatment on the last part of.
Why I'm
June.
fixing it that all similar matters are fixed.
Yes,
This exactly on that date. On 28th to complete, 4th to file, 8th. When you are coming back.
Lordship, on from 24th to up to 27th, probably I will not be here in the station, Your Lordship.
24 to, you don't need to. 24
Because
to
if I have to file my
No,
affidavit by
no,
4th, Your
Mr.
Lordship.
Anami, 24th to 27th of June.
Yes,
You are out.
yes, yes.
You are not going to make the verification.
No,
The verification will be made by the authorities.
Lordship.
You are to file your affidavit only by 4th, saying this we have verified. Nothing more than that.
I'll be very grateful if my lord can grant me after the first week of July, so that I can get the
No,
necessary.
then
Yeah.
we don't have much time now. Okay, you want to file the affidavit by 8th of July?
Lordship, if
8th of July?
yes, if my lord can kindly grant me after that.
8th of July, by 8th of July, and matter will be fixed on 10th of July.
I am deeply obliged, deeply obliged.
But complete it, you can't do like this. I'm not asking you to pay. You verify, complete the verification.
Yes.
You go for 4 years.
Yes, madam. I'm deeply obliged, madam.
For admission, item number 31.
Yes, what is this? Government has not filed affidavit. None appears for the petitioner.
Mr. Lordship, I beg to mention on behalf of the Lordship.
What is this matter about?
The pending bill of the work executed by the petitioners.
Payment of non-payment of bills.
Yes, non-payment of bill, Your Lordship.
Okay. The petitioner hearing has invoked the jurisdiction of this court under Article 2 to 6 of the Constitution, seeking a direction upon the respondent authorities to pay the admitted liability of rupees 350 lakhs due to the petitioner in respect to the works done for development of town roads for Ward number 4, Dimapur Package 1 and Package 2, along with interest. Full stop. It is seen on the earlier occasions, time have been taken by the state respondents. However, till date, no affidavit in opposition has been filed. Under such circumstances, this court for the ends of justice grants time to file the affidavit by 8th of July 2024 as a final opportunity. This the matter on by 22nd of July 2024 file the affidavit. This the matter on 26th of July 2024. But final opportunity.
Much obliged, Your Lordship.
For orders, item number 32.
Yes.
Lordship, this is the case which was listed on
Oh,
Monday.
this one.
Yes,
Very well, we need to finish it.
Lordship. Lordship.
What was that matter about?
Lordship, the petitioner was appointed and later on terminated, Lordship.
no case against the petitioner, nothing of that. They have to continue the service.
She was appointed on
petitioner in
22nd
service
of
as
February
medical
2010.
attendant at year under the establishment of chief medical officer. The pending salary
As medical attendant
with effect from the month.
on scale base. And without issuing notice, Lordship, and without any orders, written orders, Lordship, her service was terminated in 2017.
No, you were asked to appear in the screening committee. Why didn't you appear?
Lordship, in my reply.
There's a notice being issued.
Yes, in my reply, I have stated that I have not received the.
Anyways.
Yes.
Anyways, they categorically say that this is not the incumbent did not turn up for screening. There is no file number so and so. The signature of the appointing authority in the appointment order is highly doubtful. Doubtful signature of the dealing assistant in the appointment order. What to do? What will these people do?
Yes, now in my affidavit in reply at paragraph 4, I have quickly stated that I did not receive the notification or the notice.
Did they issue a notice?
They have come with a stand that they have issued a notice, but I never received it, Lordship. And in fact, no order has been passed, Lordship, terminating my employment also. It is only by verbal instruction that I was advised not to come.
Yes, madam, tell me one thing. You said that on 28/8/2012, you are hereby directed to bring the undermentioned personnel along with their original appointment orders to this directorate, so and so. Did this chief medical officer inform the petitioner about this?
Yes, Your Lordship, they were informed.
How?
The
How do
notice
you
was
know?
also displayed on the notice board of the office.
Huh?
This notice was also displayed on the notice board of the office. They were informed, but the petitioner did not turn up. The rest of them, two of
No,
them did
that
not
I've
turn
seen. Others I've seen. But the fact that you see, kindly come to page 4 of your affidavit. This is a direction by the principal director to the chief medical officer, asking him that you produce these documents along with asking these people to be present. Now, these persons did not appear in the screening committee. But the fact as to whether these petitioners were at all, the petitioner hearing was duly informed by the chief medical officer.
Yes, Your Lordship, they were informed. That's why three of them turned up for the screening committee and two of them did not turn up. The screening, the meeting minute is an extra 2.
I have taken the categorical stand, Lordship, in my affidavit in reply that this has never
Where
been
is the
received.
appointment order?
Next, 3/1, Lordship, page 13 of the petition.
You paid him the salary. Where is his termination order? September.
Lordship, there is no termination order.
Null and void and therefore non-existent. But she received the salary till September 2012. But you have not produced, how, is there any affidavit filed by that person that he has informed? How do we say that he has informed? Because here there was no direct notice issued to them.
Your Lordship, on 24th, 2nd, 2020, the High Court had directed the state to set up an inquiry into this matter. So an inquiry was set up and the inquiry report is submitted. I submitted it in my additional affidavit that was filed on 3rd of 2022.
In reference to so and so validation. Then what happened?
Then, Your Lordship, the findings of the inquiry officer, if I may be allowed to read, it's
Where?
stated in paragraph 3 of my affidavit, additional affidavit that was filed on 3rd, 2022. Paragraph 3.
Here also, Lordship, the petitioner, she was not made to
But
participate.
you see, there is no prejudice to understood. Natural justice demands whether it has been done or not, that is another aspect of the matter. But the fact remains that there was no document to that effect. It was the illegal appointment.
I perhaps could have been allowed to participate in the inquiry conducted by the state government, Lordship.
Where, how do we allow you? Tell me.
No, Lordship.
Okay, then let me come back. I
Lordship.
think, can we ask, to dispose of this petition, thereby directing the authority to issue notice to the petitioner and asking it within a period of time, and the petitioner does not turn up, then close the matter.
Lordship. I think that will be fair, Lordship.
Huh?
That will be fair.
Lordship, I may only be allowed to place a single short decision, Lordship. This has been referred in many other judgments passed by the Honorable Gauhati High Court, Lordship. My Lord is aware, Lordship, I know, but only on 311, Lordship. The division bench decision, Lordship. If I may be allowed to read the highlighted portion. Be that as it may, this is the observation of the learned circle judge. It appears that the service of the petitioner was terminated in a most arbitrary, capricious, and whimsical manner. The person cannot be thrown out from service according to pleasure of the authority. It must be done for some reason, and this reason must be communicated, made known to a person, as the authority is taking away the livelihood of the petitioner, and that was not done in the instant case. Paragraph 9. It is a declared concept of law that once a citizen has been offered a post and the citizen is working by virtue of an appointment, of an order of appointment, the provisions of Article
Counsel,
311.
there is a difference. Here, first of all, she is a temporary appointment.
Yes.
Secondly, this is a case of an illegal appointment, which is different. You cannot consider the same with a regularly, properly appointed person. So 311 can't be invoked. But however, I think the best option is to dispose it of, thereby giving the petitioners 30 days to represent before the authorities.
Lordship.
And the authorities thereupon shall take a new call. Without, I am not interfering with the order, but the authorities can take a call on the basis of whatever the petitioner places. I think that
Lordship.
that is the best way out. And if she does not place, then
I think that would be a fair, Lordship. Yes. Lordship, but if 2 months can kindly be given instead of 30 days, 60 days, 60 days.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and so-and-so appearing on behalf of the state respondents. The petitioner herein being aggrieved by not allowing her to continue as the medical attendant at the primary health center, is it under the establishment of the chief medical officer MON in terms with the order dated 22/2/2010. The petitioner being aggrieved by the actions of the respondents in not permitting her to continue in service as a medical attendant at primary health center under the establishment of the year, and also for not releasing her salary since September 2012, had filed the instant writ petition on 7/7/2017. It is the case of the petitioner that she was appointed on the basis of an order dated 22/2/2010 by the Principal Director, Health and Family Welfare, Nagaland, temporarily in a scale of pay. On the pursuant thereto, the petitioner states that her service book was prepared on 22/2/2010, and on the very date, the petitioner had also joined her service. It further appears that pursuant to filing of the instant writ petition, the respondent numbers 1 to 4 had filed an affidavit in opposition stating inter alia that the that the petitioner, along with 3 others, were found to be illegal appointments, and as such, were prima facie found to be of being appointed illegally. And as such, the Principal Director, Health and Family Welfare, Nagaland, directed the Chief Medical Officer, Dimapur, Walker Mon, to produce the original appointment orders of the petitioner and 3 others on 28/8/2012 at 2 p.m. and also bring along with him the petitioner along with 3 other persons. Pursuant thereto, the screening committee on 28/8/2012 looked into the materials which were being placed. Relevant herein, however, it is, however, relevant herein to take note of that the petitioner did not appear before the screening committee. And the screening committee, on the basis of the fact that there was no file number as DHFW-3/Mon/APPT/08-09, came to a conclusion that the petitioner's appointment was an illegal appointment. The screening committee also expressed that the signature of the appointing authority in the appointment order was highly doubtful. Along with the signature of the dealing assistant in the appointment order. Accordingly, the screening committee recommended, amongst others, that the appointment of the petitioner be treated as null and void. On the basis of the said recommendations, on 24/9/2012, the petitioner, the services of the petitioner along with 2 others have been held to be treated null and void with immediate effect. To the same affidavit in opposition and affidavit in reply was filed by the petitioner stating inter alia that she had no notice about the screening committee and she had been terminated arbitrarily without affording the principles of natural justice. It is relevant to take note of that the incident matter was taken up on 11/12/2018, and this court, by an order, directed the state respondents to file an affidavit indicating whether the purported signature of the principal director appearing on the appointment order of the petitioner at Annexure 3 to the petition was genuine signature of the then principal director or not. It is further seen that there was an additional affidavit in opposition filed on 3rd of March 2022, wherein an inquiry report was enclosed. It was found on the basis of the said inquiry that the Directorate and the Health and Family Welfare, the Directorate of Health and Family Welfare, had consistently stated that the appointment file number DHFW-3/3/Mon/APPT/0809 that did not exist, and as such the appointment order was not genuine. and there was no reason to doubt the statement of the directorate. Additionally, it was also opined in the said report that the appointment order was issued on 22/2/2010, and on the very day the petitioner joined, and her service book was also opened on the same day, which was difficult to believe that in as much as all the three activities could not have been done on the same date unless it was pre-planned and orchestrated. It was also opined that in all government appointment matters, on joining of the appointee, the appointment order is always to be returned to the appointing authority for authentication. However, this was not done in the case of the petitioner. It was also found that the chief medical officer MON, as well as the dealing assistant, had to bear the responsibility for the lapse. On the basis of the said report, the Principal Director, Directorate of Health and Family Welfare, Nagaland, had issued a communication to the Commissioner and Secretary to the Government of Nagaland, Department of Industries and Commerce, Nagaland.
May I please, Your Lordship? Your Lordship, here by court order dated 24/2/2020, the court had directed the state respondent to set up an inquiry. And so therefore they engaged the Commissioner and Secretary, Industries and Commerce Department to be the inquiry officer in this case. So this is his report.
And we don't require that. Taking into account the above, this court have also heard the learned counsels appearing on behalf of the petitioner as well as the respondents. From the materials on report, this court, materials on report as well as the prima facie opinion, as well as the reports, inquiry reports were submitted. This court is of the prima facie opinion that this court is of the opinion that this is not a fit case for interference with the order of treating the appointment of the petitioner as null and void. More so, when the said order have not yet been put to challenge before this court. Null and void order is dated 24/9/2012. Be it as it may, it is also seen that the petitioner contends that she have not been heard prior to passing of the order dated 24/9/2012, or for that matter, the petitioner was not informed about participation in the screening committee. Under such circumstances,
Lordship, I think, Lordship, the order of the screening committee was passed after the writ petition has been filed.
that I cannot say.
Lordship, The order was passed on 9th of September and the writ petition affidavit is sworn on 7th of July 2017. Lordship, yes.
You filed in 17.
Yes, I am mistaken, Lord.
When you are not
Yes,
being able to comprehend that you have approved so late. What did you write? Petitioner contends. Under such circumstances, this court is of the opinion that a liberty be granted to the petitioner to approach the respondent authorities if she continues to be aggrieved with the orders dated 24/9/2012 or the findings so arrived at by the screening committee as well as the inquiry report which was placed before this court, and as well as the inquiry report dated 19/1/2021. Under such circumstances, this court disposes of the instant writ petition, thereby granting the liberty to the petitioner to approach the respondent number two.
Lordship, I think the proper
Respondent number
authority
three.
would be respondent 3. Lordship.
Respondent number 3, by submitting a representation as regards the that her appointment order was genuine and as such, she should be entitled to be duly, and she would be entitled to be permitted to continue in service as a medical attendant. The said liberty, however, is given for a period of 2 months from the date of the instant judgment, failing which the matter stands closed. Failing which the order dated 24/9/2012 shall attain finality. This court, however, observes that in the circumstance the petitioner duly approaches the respondent number 3 by submitting a representation, the respondent number 2 and 3 shall duly consider, the respondent number 3 along with the other respondents shall duly consider the case of the petitioner without being influenced by the observations made herein above. With above, the instant petition stands disposed.
Deeply obliged.
There has to be some finality.
Yes, my lord. My lord.
For orders, item
I'm
number
obliged.
33.
Service awaited upon respondent number.
Private respondents, lordship.
Service awaited upon respondent numbers 7
7
to 11.
11.
Accordingly, list the matter of completion of service.
Lordship. Lordship.
For orders, item numbers 61 and 62.
Please, Sir Lordship. I'd like to mention item number 62. I'm appearing for private respondent 20 to 183, excluding 74 and 124, my lord. With your
These are
permission, my
all
lord, may I
illegal
con-
appointments.
my lord,
Illegal appointments.
I will not say.
These are
that.
connected
Right,
with those matters,
Right,
no?
right. Connected with 50 to 60. Right.
That series, that is why I fixed it today. You want to file affidavit?
Right, my lord. With your permission, may I kindly seek 3 weeks' time to file affidavit in opposition?
You file your wakalatnama.
My lord, I'm a proxy counsel. I'm not well aware of that.
A proxy counsel?
Right.
What to do with the proxy counsel? You cannot be a proxy.
This is the
counsel.
first appearance, my lord. First appearance.
You appear.
No, this is the first appearance.
Are you appearing in these matters or not?
No, I'm not appearing. I'm
Then who are
only a
you?
proxy counsel.
You
The
are
main
there.
counsel could not turn
You are
up
there
due
from
to this.
6 to 45. Are you not there? Yeah, you were there. Yesterday you told me. That's it.
You have filed the Bagalatama. You have filed the
You have
Bagalatama.
filed the wakalatnama.
This morning, Lordship.
My lord, this is the first time appearance, so we are yet to file the wakalatnama. If you may kindly consider.
First of all, you cannot appear without the wakalatnama. I don't understand. Is it ever heard of?
Exactly.
Yes, is it ever heard of? A person, if a lawyer appearing and says, I am first time appearing and then says, give me time to file wakalatnama.
In this case, your lordship, I have instruction to appear.
Huh?
And I have instruction to appear. Instruction to appear. So
You
I
are
think-
filing your affidavit.
Yes, lordship. And in 317, I'm appearing for respond number 2 to 5. And in 318, I have instruction to appear on behalf of respond number 2 to 19.
Lordship,
Yes.
it's linked with petition 50 to 60. 50 to 60 is ready, Lordship. We are,
So we give time for this.
Lordship.
In this
Lordship.
matter, we have to give time.
Yes, Lordship. However,
It is seen that the state respondents as well as the private respondents, though have appeared in both the petitions, but they are yet to file their affidavit in opposition. Accordingly, this court, taking into account the dispute in law, grants time to the state respondents as well as the private respondents in both the petitions to file their affidavit by 22nd of July 2024. The petitioner herein would be at liberty to file the reply if so advised thereupon by 29th of July 2024. List these matters again on 1st of August 2024.
Lordship, an endeavor to do this also.
Along with
Final
Along
hearing.
with is along
No,
with
no,
is
no, no,
today
Lordship.
decided.
This is already ready.
This is done.
Reading, sir.
Yes. Other matters over? This is okay. This is done. This court further taking into account that the other petitions mentioned in the order dated 4/6/2024, the service being complete and the urgency shown, the said petitions are delinked from the detached from the instant petitions.
For hearing, item number 37.
Mr. Lordship, this matter can be listed next week.
What?
This matter can be adjourned till next week.
Adjourned?
Yes, Your
Very
Lordship.
well.
My senior has some
Yes,
personal
yes.
difficulties.
Okay, we do one thing. Whoever don't want to do the matters, they can very well say that they want, Ms. Judge Zimomi, you want to do your matters? Okay, we start that. Others, if you don't want, you may this will be adjourned. If you want any matter prior to, what is that item number? 50, prior to 50, anybody wants any hearing matter to be done? Others will be adjourned, okay?
Much obliged.
Item number 49.
49,
Yes, we
you want to do it?
Yes, Your Lordship.
Chalo. Yes. 49, who is appearing? You are appearing?
Yes, Lord.
Yes, tell me, what is the matter about?
Before percentage taken up, if item 41 maybe is on similar things like item number 9.
Item number? 41.
41.
Item number 41 to list the matter on 13/6/2024 along with
Item number 9, which
WPC number
WPC number
259.
275 of 22.
275 of
2022. Lord.
on 13. Yes, what is this matter? Regularization.
Yes, Lord.
Again, same problems. No, this is different. The state wants to do this matter. This is direct the respondent to consider the representation submitted by the petitioner through a speaking order within the Which office memorandum you are asking for?
Lordship, while pending this matter, the state has come up with a new office memorandum, Lordship, this year, Lordship. 16 March 2024, Lordship. I mean, if they allow to place a copy, Lordship. This quite covers my case, Lordship.
This will be covered by that.
Yes, Lordship.
Then you have this kind. You do one thing. In view of that new office memorandum
Lordship.
coming,
Lordship.
you submit that you will your case be the petitioner's case should fall within the ambit of this.
Lordship.
And if the respondent authorities do not do that, the petitioner would be at liberty to approach. Court. But how can I direct if this is matter is not before this court?
Lordship.
I think that is the only way out.
Lordship.
And the earlier matter I have also disposed of in that manner. Yes. Heard Mr. Majamin, the learned counsel appearing on behalf of the petitioner, and Ms. So-and-so, the learned counsel appearing on behalf of the state respondents. The petitioners herein who are
Great for employees, Lordship.
are great for employees working on ad hoc basis.
Lordship.
Have filed the instant petition for consideration of their case in terms with the prevailing office memorandums dated in terms with the office memorandum dated 11/8/2016. Is that your case?
Lordship.
11/8/2016. It has, however, been brought to the attention of this court that subsequently, on 16th of March 2024, an office memorandum has been issued by the Government of Nagaland Personnel and Administrative Reforms Department, whereby a policy was taken on regularization of Group A and Group B contract and ad hoc employees appointed prior to 6/6/2016. Mr. Muajami, the learned counsel appearing on behalf of the petitioners, submits that as the petitioners were.
Your Lordship, there's another memorandum which covers, this is Group C, the memorandum which petitioner submitted is a different one. So this covers A and B. The petitioners are under Group C and D, Your Lordship. There's
C and D.
another.
Give me that other one. What is A and B? Let's say same date, huh? Policy, group C and D contract and ad hoc employees appointed prior to 6/6/2016. The learned council submits that in terms with that as the petitioners were appointed prior to 6/6/2016 on ad hoc basis, their cases would be covered in terms with the office memorandum dated 16/3/2024. He therefore submits that the case of the petitioners now ought to be considered by the respondent authorities in terms with the said office memorandum dated 16/3/2024. He therefore submits that as the earlier office memorandums are no longer in existence, the petitioner would not, petitioner or petitioners?
Petitioners, Lordship.
One.
8 of them, Lordship.
Petitioners would not therefore like to press the instant writ petition. However, he observes that in the circumstance that the petitioner's cases are not considered in terms with the office memorandum dated 16/3/2024, the petitioner should not be precluded from approaching this court. Upon taking into account the office memorandum dated 16/3/2024, this court is of the opinion that the earlier office memorandums on the basis of which the petitioner had based their claim, no longer survives to take into account the case to the aid of the petitioners. Under such circumstances, this court grants the closes the instant writ petition on withdrawal. However, it is made clear that the withdrawal of the instant writ petition shall not preclude the petitioner to approach this court. In the circumstance, the petitioner's case is not considered in terms with the office memorandum dated 16/3/2004. Yes. Yes, madam. Yeah, madam. It should be the lead matter.
Lordship, this is regarding
No,
that-
which would be the lead matter?
first one, 189. It's all the same. 189.
189.
189. That is the first
All affidavits are filed in that matter.
50. That's still number 50.
Hey, this is-
Uh,
all insects inside. Yes.
Lordship, this is a writ petition pertaining to appointment of constables in police department. In the first writ petition 189, we have 53 respondents, Lordship. 53 respondents are from NAPTC Chumukidima, first NAP 36. NAPTC Chumukidima consists of 13 respondents. First NAP consists of 36 respondents. Then first NAP IR Mahila consists of 4. A total of 53 constables, Lordship. Now what has happened is, my Lord will kindly come to the A to A2,
So you say that these appointments have been made without following these are NPSC posts?
no, Lordship, it's not NPSC post.
What are these posts?
This is grade 4,
Grade 4.
yes, Lordship, constable
All these
post.
grade 4s have been appointed without following.
Advertisement, Lordship.
No advertisement.
No advertisement. That is
Then
the only
what are the
question.
rules- What are the rules followed out here in Nagaland as per grade 4?
Grade 4 post, Lordship, advertisement is required.
What is? they have
There is no
advertisement
service rule,
based
but
upon Either some executive instruction or some rules where,
instructions, administrative instructions.
where is that?
What's called the grade 4 posts. They are not. No, these are posts which actually falls within the purview of now NSSB
And?
Nagaland Staff Selection Board rules.
So you have some regulations, rules?
But then, so far as the constable is concerned, post of constable, that is excluded from this.
So what do you follow?
Now, your lordship,
You feel,
so far as the posts in questions are concerned, they are appointed as per the Nagaland Police Manual.
police manual.
My lordship.
Now, does the police manual show me?
Lordship, they were appointed prior to constitution of establishment of NSSB. So, these constables, NSSB came only after their appointment.
NSSB, what is that?
Nagaland State Staff Selection Board. It came into being just 2020, and they have been appointed prior to that.
They were appointed in 19.
Yes, Lordship. And here in this matter, I have annexed 97 to
These are all group C posts.
Group C. Group C and Group D.
So NSSB only came into existence in 2020.
20,
And these appointments are of 2000.
prior to,
So this will have no relevance.
Lordship.
Yes. Now, prior to this, your lordship, there's an OM issued by the PNR department relied upon by the petitioner. The OM is issued on 7th of July, 1976. But subsequently, that has been superseded by another OM dated 12th of December, 2016. And by that OM also, the post questions, those are excluded, your lordship. So even under NSSP, your lordship, these posts are excluded, your lordship. So what I'm trying to impress upon your lordship is that so far as the post in questions are concerned, it has to be as per the Nagaland Police Manual.
Okay, what does the police manual say?
Nagaland Police Manual, page,
Your lordship,
chapter 2.
I have flagged your lordship. I have flagged. So far as
Part 3.
I have flagged your lordship.
Pay and appointment of non-gazetted officers. This won't come under officers.
Now, so far as the post of constable is concerned, Rule 20, your lordship. Rule 20. That is the last.
After enlistment of a
Okay,
superintendent of police will make all appointments of constables.
After
After appointment of constables will be sent to the police training to be enlisted from the main area. Possess sufficient intelligence and areas to be made from each tribe.
And Rule 8, your lordship may also see Rule 8, that is appointment of sub-inspector. This was also Rule 8, your lordship.
Direct recruitment. We are concerned with direct recruitment of
Yes,
sub-inspectors also.
Yes.
That is in another repetition, Lordship.
Oh, that is in 317.
That is in the
Earlier-
segregated one, earlier one. Yes,
Okay.
that will come
Now,
later.
we are concerned with the post of constable.
Rule 20.
So you say that this enlistment of the constable can be done as there are rules or there's nothing out there to say what is to be done.
Yes,
You can just pick and choose anybody.
yes, exactly.
Yeah, going digital.
No, isn't that the case?
If you go by that, your lordship.
No,
right.
because Mr. Jamil, only one thing,
Yeah.
only one thing. What do you mean? After Manoka Gandhi's judgment, procedural fairness had become a facet of Article 14 and 21. Under such circumstances, can a state take any action without any procedural fairness? There's no procedure.
Your lordship, I have few writ petitions pending where I'm challenging the state action of the state respondent in making appointment without advertisement. Maybe tomorrow it may be listed. Where I am for the petition. Now, here I am on the other side. But your lordship, this is a case where the petitioners, they are challenging even those appointments made on compassionate ground.
No, that
appointment
is
made on
another.
Those,
right
those will
ownership.
be segregated. out.
Yes,
I'm not on that.
yes.
I'm
And-
only concerned
Yes.
with those appointments which have been done without following any process. Compassionate appointment, okay. Land ownership, okay. All these other appointments are not, because you have a scheme. But if there's nothing, if it is nothing is there,
No, there are also appointment which has been challenged, which the appointment made on the basis of recommendation of what recruitment test or selection committee.
Oh.
Selection committee.
understood. So if there is a selection committee, there has to be a basis of a selection committee.
Correct. Your Worship.
Selection committee is also formed on the basis of some rules or regulations or whatever may be, or even executive instructions.
So
Is there anything to that effect? Because here, this police manual does not conceive of a selection committee.
rule is silent, but then though rule is silent, as per the appointment order, the appointment has been made. Not all, Your Worship, not all. There are appointments, some appointment which have been made on the recommendation of the selection committee, or a recruitment test also done based on that recruitment test.
Where is where is the appointment of a selection committee? Where is the appointment of a selection committee?
Committee, Your Worship.
That is also relevant.
Lordship.
Is there any appointment of a selection committee?
No, that I have not annexed based on report, but the appointment order itself mentions.
Understood. Appointment order may mention many things. It may look for that to make it very looking beautiful, everything you can put. But the question is whether a selection committee at all was constituted.
That I don't have on it.
That's a very vital aspect. If that is mentioned out there and there is no selection committee constituted. And what is the parameters of the selection committee to consider? Yes, the rule says that he has to be class A. He has to be doing certain thing. He has to have a good physique.
Yes.
You are having constable. He has to have a good physique. Did you have a training? All these things has to be there. So something has to be there. How do we take care of this situation?
Regarding training part, all of them they have undergone the basic training.
Right.
That is done. But,
In fact,
but your lordship is right, so far as that how the committee, constitution of the committee, that report, lordship, I don't have. But going by the appointment order, appointment order itself, it is reflected. On the
understood, but unless you show that there is a selection committee constituted, you take care of. And if not only that, the selection committee had held a meeting, fixed the in the minutes that this is the procedure we are going to follow.
I've understood it.
So this is the how it is. You can't help it without that. But we need to segregate those who are on compassionate or land ownership.
Lordship.
Yes.
In
We do
fact,
one
I,
thing. We do one thing. We take it up tomorrow also. On that day, you come up, find out and give me a list which are outside and which are not there. Because so many matters. How do I know?
In fact, Lordship, I have segregated all the compassionate appointment
No,
and
no.
landowners,
Mr. Ravi
the
said-
appointment orders.
Now, anybody who have been given
it
on the
carries-
basis of a, yes, a person can be, there can be an enlistment of AR on the basis of this. But for that, they need to have a selection.
Lordship.
Now, for the purpose of compassionate appointment also, a person we can be given, provided
Lordship,
he
that
comes
is
within the
okay.
ambit of that circular office memorandum.
Of course, Lordship.
But the office memorandum also conceived of a selection in a particular manner that it will be done chronologically. These are the people who are going to get it, how it is
Exactly,
to be developed.
Lordship.
There has to be made an application. Whether these have been done or not, that is another aspect of the matter.
Exactly,
Very different. Now, the second aspect of the matter, for that again, you don't need an advertisement.
Yes.
As regards the land ownership, how they have considered, that is also as per a particular circular, wherein it states how it is to be done. So
Yes,
that is
Lord.
another aspect for which again there is no requirement of an advertisement.
Exactly.
But however, in respect to these, procedural fairness has to be there. In fact, there is a very beautiful judgment that day I was looking into, Mr. Dev. The judgment by my Justice, Chief Justice of India presently, uh, Madhyamam Broadcasting Corporation Limited. That is the case of Media One, where the license was not extended by the central government. On the ground that he said something in the TV, the anchor or the editor said something in the TV, so the central government said that no, we are not going to extend this. So the matter came up before the Supreme Court. Supreme Court went into the aspect of what is procedure established by law in 21 has been incorporated to mean that the procedure should be such that the process should also show the fairness. And as such, brought in that concept which is there from 1975. Very beautiful. See the line, I'm just reading that line. It's very beautifully said. This court observed that the right to go abroad is an extension of the right of life and personal liberty protected under Article 21 of the Constitution. This right
Manika
was
Gandhi.
observed.
Manika Gandhi.
Yes. Then it was said, relying on the True jurisprudential development on the interpretation of Part 3 of the Constitution must be noticed to understand the impact of constitutionalizing the principles of natural justice. The first is the expansion of the meaning of the expression procedure established by law, as it finds place in Article 21 of the Constitution to include procedural due process. The second is a shift from reading the provisions of Part 3 of the Constitution as isolated silos to understanding the overlapping tendencies of the fundamental rights. Then it said about A.K. Gopalan, wherein the Justice Fazal Ali said about this thing. And therefore it says that if there is a procedural unfairness also, it would violate Article 21. So in this case, to draw an analogy out here, if you have nothing, wouldn't that violate Article 21, 14? Therefore, it says the silos of overlapping of the fundamental rights. Because at that point of time, prior to Maneka Gandhi, it was a concept, 14 is this, it's compatible rights with 14 and 21. Now it is being overlapped. That is what it has been meant. So, if there's nothing out there, what to do?
Lordship, not tomorrow, let the matter be part heard, and Thursday we can discuss.
I will finish up the matter and go from here. Don't
Without that parties. This is a matter where without even the parties also my lord can
No,
settle
no,
it.
I'll just, if I can produce a report, how the whether screening committee has been constituted, not just to place that on it more. Tuesday, your lordship, let the matter be part heard.
Okay, Tuesday.
Yeah, tomorrow maybe.
Because I delivered the judgment in the court itself. No,
It's already more or less delivered. 50% delivered.
Lordship, the question here is the constitution of a committee.
Huh?
Constitution of screening committee. Who are they screening? Without
The
advertising.
matter upon being heard, the matter has been heard. It is the specific case of the petitioner's hearing. That the private respondents hearing who have been appointed are appointed by the state authorities without following the due process. Ms. Jejimovic, the legal counsel appearing on behalf of the petitioner, adding to her submission that there is no advertisement. There is nothing mentioned on what basis the petitioners have been selected. The private respondents have been selected. And it's on the face of it, it appears that it is an arbitrary exercise on the part of the respondent authorities to appoint certain persons by a pick and choose method, which violates, which on the face of it shows the arbitrariness and violates the mandate of Article 14 of the Constitution. The Legal Counsel for the petitioner further submits that in the instant case, as the due process have not been followed and there being also no procedure established, it also violates the mandate of Article 21 of the Constitution. During the course of the hearing, a question arose as to the question arose on the basis of the upon perusal of the appointment orders, wherein it has been mentioned that they on the basis of some selection being conducted by a selection committee. Under such circumstances, this court sought instructions from made specific queries to Mr. T.B. Jamil, the learned counsel, representing the state respondents, as to whether there was any selection committee constituted. Or, semicolon, did the selection committee formulate any procedure? Semicolon. Did the selection committee record any minutes? Semicolon. Did the selection committee keep any records of the physical? Characteristics of the persons, of the people, of the private respondent, of the candidates who have been appointed prior to making recommendations? And did the selection committee make the recommendation to the respondent authorities, and to whom and when? Under such circumstances, the learned counsel, appearing on behalf of the respondents, sought for some time for obtaining instructions. Accordingly, list the matter on eight, on 11/6, 11/6.
As part.
As part
And shown as part of.
Obliged.
obliged lordship.
Your Lordship, sir, the matter that day I delivered, na, asking the fact-finding inquiry. You take that order to the, also to the district judge, and you participate. Because the commission of inquiry is there. I've given them the powers in the commission, the district judge shall exercise the powers of a commission in terms of the commission of inquiry. So she will have the various power as regards calling for attendance, everything. So you just played it out. I forgot after today only I remembered asking you to participate. So kindly take it up with them.
Lordship, item number 42, 43, 44, in the morning, the counsel for the petitioner on medical ground has prayed for short for adjournment regarding that low price. So if the matter will be listed next week.
Who that located? What happened? Where is the counsel?
I am open to the morning that counsel for the petition on behalf of the
Next
petition.
week, I suppose, next week I'm not fixing those matters because the thing problem arises, I may not be taking up this bench. Justice Zamir is coming. So he will be there. We'll have the chief justice also.
Then
Chief justice will be there. Many judges will be there. So I'm not fixing that matter
No.
there. This I'm doing it because then I can, I've already.
Obliged.
Yeah. Yes, yes. Dismiss. Right. Yeah, I have written. But I just wanted to make sure. Dismiss with liberty to file.
Mua, your item number 41 that you mentioned, no? When the key date takes experience, 1-3, no? अच्छा, अच्छा, oh, अच्छा, अच्छा, okay. So 9 sorry, 9 किती आहे special आहे? 9 is also, yeah, already fixed on 30. ठीक आहे.